what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! My God!
Before they
Don't
finish this
get
one.
brazen with me.
Hey, good morning, good afternoon, good evening, everybody. Hi, and welcome to today. This is the thing we're doing. Right now, the actual live trial is on Verdict Watch. So Steve, I don't know if you're feeling up to it or have time or if you're able, but I did send you the link. And clearly, judging by our chat poll, they want you here. So, if it ever falls within your schedule, you are welcome here. I will send you links every day. We talked about this a little bit earlier, so it's up to you how you feel and what you have time for. But what we're doing here today, what we're going to be doing, this is a new thing we're trying here. This trial, and well, that was fast. That was quick.
Well, I'm going to do something a little unusual today. I will have one ear cocked to the trial and then one ear working on. I'm going to work because I have something that I can probably do while I'm online. So I'm feeling a little better.
There you go. I'm glad you're feeling better. You're sounding better.
I'm sounding a little better. I can still feel it. But anyways, well, thank you for letting me on.
Well,
the chat demanded it. The poll demanded it.
It is.
And this is a good judge. I will say this is I think it's the only judge I've given an A to.
I think so.
So
in the whole entire, we'll get to his background here in a bit. We have Steve Gosney on here, everybody. And as we doing some quick housekeeping here, we've got 365 people here now, 110 likes. Please hit that like button, hit that subscribe button. Make sure you're still subscribed. And while you're at it, take a little breath and go over to stevegosney.com and see what Steve has there, including 2 books you can order.
Yes, the new book is I'm going to have the first shipment in and I'm going to satisfy all the pre-orders, I think, on Wednesday. Mm-hmm. Although I have one shipment that's running late for some reason. And then everybody can, get the new book, Prepare, and get the old book, Law and Ideas and Answers in Law. And also, we got the Kickstarter campaign going, which we have fully funded. The law cards with me and Farmhand Tom. Yeah, there you go. You got it. Look at you.
And yours truly featured prominently in the card deck. Well, at least one card.
No, I have another one I just came up with.
Oh, yeah,
and that is Legal Vices is strangely obsessed by cannibalism.
Oh, there you go. That's a good
one. Or another one would be Legal Vice is packing for his overnight boat trip, and he'll be putting utensils, knives, and forks in
Yeah, we need a cannibalism card. We definitely need a cannibalism card, and maybe an F it Friday card. So some sort of drunken nonsense.
Yes,
because you've got the get girl drunk card, so I need like the F it Friday drunk card.
Well, and I will tell you that I really want to. I'm going to get with Tom, and with your consent, of course. I want to do a whole Legal Vices deck of just Maritime Mondays, because cool. I think your I gotta say, I love Maritime Monday. Every time we get it, it's like, okay, we're watching this stuff, and you're like, man, I'm glad I'm in my office on the way in. Starts Monday out good.
It does. Oh, well. So we've got the poll up. Take the like and subscribe button. Take the poll. Today's poll, so far, 22% said I crushed the like and subscribe button to vote yay, I have something to do now. 24% of you said I crushed the like and subscribe buttons to vote let's do this. And a full 54% of you, near a super majority, said I crushed the like and subscribe button to vote let's get Steve Gosney on here. There you go. See, Steve's always he's always humbling. Oh, come on, if people want me. So there we cut that complaint off at the pass.
Well, that's why I'm here. And I love the Vice Squad has got to be, I got to say, the Vice Squad puts most chats to shame. You guys really have a great chat. I love it.
I love my chat because it's not milk toast, wishy-washy, but it doesn't go full Ricada. It walks the line.
Well, Ricada's chat's good. It's that local stuff that he's got going that's kind of wild and woolly.
So we've got what do we got here? We've got one super chat so far. We'll clear that out of the way, which is can't possibly be Brandon. Says, finally, we have a real lawyer on the stream. What am I, chopped liver? Well, it could be after Cannibalism Day, but anyway. What we're going to do here is because this trial right now is on verdict watch. The verdict could come down today. It could come down tomorrow. I know nothing about this trial. All I know, it was a hung jury the first time around. That's all I know. Okay, I did see one thing that apparently his previous lawyer said that it was a hung jury with 10 of the 12 voting for acquittal. So that's the only thing I know about this. And so I'm going into this cold. I purposely watched. This trial got overlooked and ignored because a chunk of people were watching the Zachariah Anderson trial. And when that started to wrap up, this absolute goofball of a trial, Gwyneth Paltrow thing, is going on, and that has the just the weirdness, wackiness factor to it. But this is something a little more serious, a little more in depth, and that's what I wanted to show. And we're doing this in a different way, so that I can get some sleep, and and we can do it normally. We'll show the morning session one day, the afternoon session the next day, and then we'll keep going that through the full day of the trial. And it allows us to watch it a little bit faster. We can skip the breaks and all of the sidebars and the lunch breaks. So we'll see how that goes. And if it's something that you guys like, we'll continue doing it. If it's something that nobody shows up for, and quite frankly, isn't economically reasonable for me to stay awake, if you pay me to stay awake, I'll stay awake. That's the crass way of saying it. But that was like with the Murdoch trial. Emily D. Baker was streaming it. Nick was streaming it. And we'd get a couple of hundred people in here and you get like $30 out of it. And frankly, getting $30 isn't worth staying up till 4 o'clock in the morning for. But we'll see how it goes, because everybody was very, very generous and went very, very well during the Zachariah Anderson trial. I want to see if it can happen as well during a delayed trial, where we will clearly know the outcome of the case before we actually finish the case. But
and if there is a verdict, we probably ought to switch over just to watch the verdict, right? And see. Yeah, well, I mean, it's going to be out there, but it's going to know.
Yeah.
We don't want to.
Well, yeah. Well, some people may want to keep it spoiler free as possible, but that'll never happen.
Yes, and I'm not insulting. I'm not insulting any other chats. I'm just saying that the high bar that the Vice Squad gives is quite hard to compete with. Brackets did write the intro to my new book, Prepare. So
he did,
and I'm more of a daytime Rackets guy than a nighttime
guy.
Yeah.
And we have Flux bringing in another super chat. Steve did it.
Flux, love Flux, man. Flux could come on too, man. She could live stream stuff.
Vices does it for passion, says can't possibly be Brandon. Steve does it for the Vices does it for the money. Steve does it for the passion. Clearly, you've never seen Steve talk about his book.
Well,
he does it for the money. The book is his passion. The book is your passion, but
the book is my passion.
You certainly grift for the sales of your passion quite well, which you should.
The thing is that I really want people to read it. It's not. I don't want them to just buy it. I do want them to buy it, and I want them to compensate before my life's effort. But I want you to read it more than anything. I mean, that's the thing. I want to get the message out, and I'm trying to widen my. In fact, I've got a plan of action for how to, especially Prepare is the one that I really want everybody to read. So I've got a plan of action for broadening my basis outside my circle that I've kind of developed here.
We need an audiobook. We need an audiobook. Just get a good narrator and people will buy it.
I'm going to read it. I'm going to do an audiobook of my Prepare book. But you're going
to read it yourself. Okay.
Yeah, I'll read it. And also I'm going to do an ebook, but it's going to be a few months. I've got to get through the first sales, get through promotion. I've got so much on my plate,
No, can't possibly be Brandon said I paid $3,000 for my book. Yes, you did.
Who was that? Whoop, I missed one. What was that?
That was the Brandon Collective saying that he spent $3,000 on his copy of the book.
$3,000? No, it'd be $1,000. I don't know. $3,000? I don't know, but he definitely was a big hero. If that's definitely not Brandon, he's a hero. He helped give all the pre-orders an upgraded cover. But the new the original, the cover that's on it now is actually I'm really pleased with. So, but thank you to your and that he's part of the Vice Squad. I'm not sure how he met me, but that was here. You remember when he gave a big donation to support the book. So thank you.
That is true. So let's kind of get on with this here and see how the day goes. Right, checking things out.
Yeah, and there's really no discounts. The only discount code I have is for people who want to buy more than 25 books. That's on there. It's part of the thing. And I don't really believe in discounts. The problem is you give a discount code and everybody gets upset because they didn't get the discount. So, I don't do like $29.99, or anything. It's like it's a 24. That's it. So, but thank you for the thoughts.
Don't be cheap. Pay the full price. He deserves it. It's his life's work.
Yeah. When do you sleep exactly? How much sleep do you actually get? That's my question.
I average about 5 hours a night.
5 hours a night?
And now that I tried to talk and do something at the same time, it didn't work out here. I got to bring this back up. Yeah, I get about 5 hours a night usually. But I got 7.5 hours sleep last night. And my body didn't know what to do with it all. All right, let me just quickly bring back up what I had up before I started clicking buttons and ruining everything. Got to go to the law and crime, go to the live streams, go all the way back in their history to day uno. Just day one. This should be day one.
And the only place you can get the book is stevegosney.com. And I'm open to anybody's suggestions on how to get the word out. I want to get everybody out that the first printing here, I want to get those all out so everybody can read it and they can see what it's about and suggest how we can expand this circle, because we need to get the word out. We need to get more reasonable people, free-thinking people, freeing people from the tyrannies of our country and the external, and freeing people from the tyrannies of their own minds. So that's what it's directed to. And once you get it and read it, I'm open to suggestions. I'm looking forward to it.
All right. And with that, I think I've unintercoursed myself and we can get going. After can't possibly be Brandon says Henry Ford was a short sleeper and he invented the assembly line. So was the H-man, and he used his spare time differently. It's all what you do in your spare time. And on that note, let's hit with the opening statements. We'll hear from the judge first, and then we will hear from the lawyers. And for those of you that don't know and haven't been following along at home with my tweets and whatnot, the judge is Judge Sabella, who presided over the Matthew Terry murder trial we talked about a few months ago, which we affectionately called Stabby McStabface, who stabbed his girlfriend multiple times and then slit her throat and found guilty. And it was without a complaint. Steve had one minor issue with an action by the prosecutor near the end that was so minor I can't even remember what it was.
I remember it was a withholding of the jail calls. Remember they had the witness.
Oh yeah.
And they call and they didn't tell us, and then they tried to surprise attack the defense. Yeah. But the judge covered it. It was a dirty move, and he lost. That prosecutor was so good. And I also think they should have switched out the prosecutors at the penalty phase, because his aggression in the penalty phase was not appropriate. So the prosecutor got a B. Is this the same prosecutor?
Mm-hmm. It's a different prosecutor, but the defense lawyer is the defense lawyer that won the acquittal for the retired policeman in the movie Popcorn Murder Trial.
Okay, we covered that one too. I remember that. And my buddy was on that trial. That was on the defense team.
Cool. Well, this is Richard Escobar, who is the defense lawyer in that.
Well, he was on the second. Actually, he moved out of that firm after that victory. So I think he's in South Florida now doing probate.
Righty here. So let's start this. We'll hear from the judge, then we'll hear the opening statements this morning.
We formally would like to All right, if there's any witnesses in the courtroom, the defense has invoked the rule of sequestration, which means that you are not to be present in the courtroom while the testimony is taking place. So I will ask you to please step outside. I'll also ask the state to inform all of their witnesses regarding the invocation, and the defense to inform all of their witnesses regarding the invocation. The bailiffs who are sitting at the back when someone comes in will normally ask them if they're a witness, and if they indicate that they are, we'll let them know. But as long as you let all your witnesses know, that shouldn't be an issue.
In here, but also on court TV.
Well, you know what? Absolutely instruct the witnesses, because we've had that come up before where we're being live streamed or broadcast in any other means. So please make sure that you let your witnesses know that means they can't watch any reports of the proceedings or live stream of the proceedings, both sides.
If any of you watch my channel, don't. Not until it's over. Then you can you're welcome. All right, let's bring the jury in.
Yeah, I remember this judge. He's my favorite judge I think I've seen on any trial that I've covered. He's fair, he's smart, he's quick, he's efficient. I really do like him.
And he's just so personable. Even down to telling every single witness that the microphone is fully adjustable. I've got 704 people and 351 likes, like one person shy of 50%. Make sure you hit the like button and the subscribe button. And then you can take our little like and subscribe.
Else may be seated at this time. Ladies and gentlemen of the jury, good morning. Welcome back. Happy Monday. And thank you again for all of your hard work last week and your patience with us during the selection process that took 4 days. I hope you enjoyed the Friday that I gave you off because you had worked so hard with us all week. And thank you for coming back this morning. I hope you had a nice weekend. We are going to get started. There's a couple of things that I need to do with you before we begin. One of them is read you some preliminary instructions. I do apologize for reading to you, but every word of them is important. They
this is a really loud court.
Supreme Court, and I don't want to inadvertently or mistakenly leave something out. The other thing that I want to mention to you before I begin with the instruction is that you may notice that there are cameras throughout the courtroom. Those cameras may be related to reports outside the courtroom, media, and things like that I have also warned you through every stage of this and every night and every break to avoid any reports of the case. You are now in a new courtroom. This is my courtroom. It's a little smaller than the courtroom across the hall, but you do recognize, as I said, that there are cameras in it. So a couple of things with that. First, I want to instruct you not to be concerned about those cameras in any way whatsoever. They should have no effect on you. They also know, whoever is behind those cameras, not to show your likeness in any way. They will not do that. So the cameras will not show the jury at any time. The other thing is that means that there will probably be reports about this case outside of the courtroom through the course of the proceedings. So it is very, very important.
I think he has a really good courtside manner, the way he explains things so clearly
media,
and
print
well.
media, television media, social media, anything. I think I said social media to begin with. But any reports, as you know, and I apologize for being redundant about this, but I've done this a few times, and unfortunately it happens. Somebody might be inadvertently exposed to something, and then we have to address it. I'll ask you every time, as I'm about to ask you now, since you had Friday, Saturday, and Sunday, whether anybody was exposed to anything. But I just wanted to let you know that we're going to continue with that same rule that you cannot discuss the case with each other, you cannot discuss the case with anyone else, and you must avoid all reports about this case outside of the courtroom. So I want to ask now, before I read you the instructions, by show of hands, was anyone exposed to anything about this case between the time you left the courtroom number 1 Thursday night, I think it was, when we finished and got you out of here after 6:30. So Thursday night, and now that you've walked back into now this courtroom, we're going to try the case. Anyone by show of hands exposed to anything about this case? Let the record reflect no hands. Anybody discuss this case with anyone else amongst themselves or with anyone other than the jury? Let the record reflect there are no hands. Again, thank you all very much for your attention to those rules and your patience with us. I am now going to read to you the preliminary instructions. Part of those instructions tell you how the trial will proceed so that I don't have to keep yelling. Not that I was yelling at you, but I'm going to turn on my microphone while I read. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of State of Florida versus Michael KEETLEY. This is a criminal case. Michael KEETLEY is charged with murder in the first degree, 2 counts, and attempted murder in the first degree, 4 counts. The definitions of murder in the first degree and attempted murder in the first degree will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Michael KEETLEY in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instruction on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of
all right, I'm just doing a quick volume check here just to see how we are compared to the court.
Notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorney.
We're going to step this up to 1.25. See how that sounds.
Investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, or any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussion of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family member make comments to you or ask you questions about the trial. In this age
What
of
was that
electronic
question?
communication, I want to stress again that just
No,
as
it's
you
about
must
All
not talk
preliminary
about
instructions for the jury.
face-to-face,
What you're
you must
interested
not
in
talk
is
about
the
this
opening
case by using
statements
an
of the
electronic
parties
device.
to frame the
You must
issues.
not use phones, computers, or other electronic
What was that
devices
Yeah.
to communicate. Do not send or accept any
Well, yeah, we'll take a quick break here. We got through the important part of this instruction, so we don't need to hear the "don't talk to everybody." Now let's clear these super chats here, and then we'll get into the opening statements. Serial shot dodger. My name is Chandler. What about Borowski, Steve? And to the chat, Jeff will shut the stream down if we don't get 1,000 likes. So get to it. Reach down and flick that thumbs up. I won't do that.
Which
but,
judge was that? I don't remember him.
Judge Borowski was the one that did the Edgecombe trial.
I didn't watch Edgecombe, so I don't know him.
He was gruff and to the point, and he kind of hated everybody, including his job, and to the point where he's growling at the people after lunch. He's like, "Oh, hope you survived lunch."
The key factor for a judge that you need to be to look for a good judge is fairness. Fairness above all.
He was as fair as I guess as he could be. He just was dealing with some idiot defense lawyers. His favorite phrase was "Chambers now." God, it's time for a lunch break. Hope they're not serving fish. Good luck. Things like that. He was a gruff old judge. I loved him. He was a grumpy old codger, but I think he was very, very fair. And as far as the likes, please hit that like button, and that's how we get YouTube to know we're here. We smash the like button and subscribe if you haven't already done so, because that tells me that you like me and it lets YouTube know we're going. We're continuing our quest. We'll just say it real quick here. We'll do the one grift for the subs. We're on our quest for 50,000 subscribers. We are currently at 36,005. So a couple hundred by the end of the day would be awesome, but I know that's not going to happen. But if you haven't subscribed, I'd be happy. And Chaos Coordinator said, yes, chat. We watched one trial with this judge before. He's a good and fair judge, not like those a-holes during the last two trials we've watched. Enjoy the ride with our favorite boomer, Jeff.
Yeah, I missed the one. I just saw the Murdoch judge, and I started out thinking he's okay because of his soft-spoken nature, but the more I listen to him, the more I'm like, he's not fair. And although I've seen a lot worse, but this judge, to me, in the last trial we covered, he was excellent. So I'm hoping that wasn't a one-off. I'm hoping that he's going to maintain his consistent, fair rulings, and we shall see. Well, there was another super chat, though, I think.
Yeah. Dara the Wholesome says, important to note what's loud for you is just a bit above regular volume for likely many others and I. You two are much louder than the judge now, but we got that all worked out. I worked quietly behind the scenes. We should be great now. Mandalore Wise 01 says, question primarily for Steve. Should one of us chatters be placed on a jury, what would you hope we do to do our due diligence? Any recommendations for what to watch for in testimony and any tips for memory in long trials?
That's a very, very good question, actually. First of all, hold the state to the burden of proof. That's the main thing. If you can take notes, don't get distracted from listening. Focus in on what the issues are in the case, and then zero in on that. Don't get distracted by all the talk and all the frivolity and the fact that somebody's wearing a fancy uniform or anything else. Zero in on what is the issue in the case, and then did the state prove those elements beyond the reasonable doubt? I mean, that's what they instruct you to do, and I think that's a fair thing. Don't try to solve the case from the jury box. Because there's a mystery. Oh, I know what happened. Ha ha ha. Right? That your job it's not an Agatha Christie novel. It's the state has to when you walk out of there, you got to say. And it's funny because I got a quick story. I had after I got done with the Murdoch trial, I'm like, it was 6 weeks of just confusion. Everybody's like, we are so confused at the end about what their theory was, right? And then I come in, and of course, I review trials. And there was a case that came in, and I can't tell you which one, but there was a case that came in that was the case was so clear and crystal clear that it was like there was no questions, right? I mean, and that's like, oh, there's what you call proof beyond a reasonable doubt. So so that is my big advice is hold the state to their high burden, listen to the issue that you're being asked, what is the question in dispute in the case, and then look to the state to say, did they resolve it? Beyond reasonable. So you go away and you got doubts. Don't try to solve the puzzle. That's not your job. And be reasonable and listen. Open ears. Humble.
And let's go. Brandon says, there we go. All is right with the world again. Someone stole my handle, though. I will follow you down till the sound of voice will haunt you. And Vince Clortho, do you guys prefer quiet sidebars or the way Wisconsin seems to be doing it by excusing the jury and doing it in public?
Well, that depends on the length of the sidebar. So, if you've got something that is of appellate level, then they should excuse the jury so bar parties can get full-throated view. A sidebar where you just go up to the bench, that's usually something that's maybe an evidentiary objection that doesn't have the appellate impact. But I think if there's something that needs to be preserved for appeal, you should excuse the jury.
See, and I like the way Schrader does it, but I mean, he tends to go off on long tangents. Like, oh, well, that reminds me of when Cicero and I were discussing, but as he said at the beginning, I do it this way so that when the appeal inevitably comes, the appellate court knows exactly what the objection was and exactly what I thought about it and exactly why I ruled the way I did. But he could do it a little bit briefly. And Lori K. Farr, how long was this trial before it got to the jury? It was 10 days. It was a 10-day trial. And the jury is deliberating as we speak. So I fast forwarded to the beginning of the actual opening arguments.
Statements. We want to hear opening statements.
Sorry. I said opening arguments, didn't I? Shame on me. I wish I was a real lawyer like
what
Gosney.
The opening statement is a preview of the evidence that both parties believe the evidence will show. So it's a predictive. In fact, in Ideas and Answers in Law, you can read about how a prosecutor should do this in the chapter on how to prosecute ethically. And it's a preview, and it's a good chance for the defense to say, here's what we want you to look at. Like, okay, somebody died for sure, but the question is did our guy do it? Or was there some other thing they're going to want to focus your attention on? So it's a good place. It's a good way to kind of get a preview of upcoming events.
All right. And then it should be a roadmap for what each side is going to show. And everything that they do during the trial should be to add one more brick in that roadmap they told us about. So that's those of you that followed the Anderson trial. When we went back and watched the opening statements, you saw that they were radically different than what actually happened in court, which is just, anyway, we won't get sidetracked by that. Let's bring this up and get it going. Opening statements are happening today. We'll start with the first witness tomorrow on the stream. So let's hear.
Are you streaming also on Rumble?
It's a backup site. I don't stream live on Rumble. Okay. It's just kind of a backup that gets uploaded there eventually a little bit after.
Memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. That is all of the written instructions. What I want to do now, ladies and gentlemen, before we begin with the opening statements, is to ask you to take your pens out and take them for a test drive to make sure that they are in working order. We recycle pens.
He's such a helpful judge.
Run out of ink. I want to make sure they're working when
test
we get
your
started.
pens. The microphone is fully adjustable.
Please not pan, run out of quantum.
Okay, I think it's weird there's a little kid there in trial for a trial of this nature, but good for them for their civics lessons.
Ladies and gentlemen.
I assume they're family members.
Obsessing about revenge.
All right, here we go.
That's what this case is about. Obsession with getting revenge is what was on the defendant's mind the early morning hours of November 25th of 2010. The only thing on his mind, those early morning hours of that Thanksgiving morning in 2010.
Oh, it's Thanksgiving.
When he shot and killed 2 innocent victims, 2 brothers, Juan and Sergio Guitron, and tried to kill 4 other victims, who fortunately survived the horrifying events of those early morning hours. Those 4 victims being Richard Cantu, Ramon Galan, Gonzalo Guevara, and Mr. Daniel Beltran. In order for you to understand how we got to the obsession with revenge on November 25th of 2010, we need to go back to January of 2010, almost to the day 11 months prior to the horrifying incidents of that Thanksgiving morning, where in January of 2010, when the defendant, Michael KEETLEY, was working as an ice cream truck driver in the Ruskin area, and he was robbed by a Black female and 2 Black males. The Black female had approached his ice cream truck and had attempted to make a purchase when 2 Black males came up, robbed him of $12, and shot him. Mr. KEETLEY sustained injuries, and he contacted law enforcement, where the Hillsborough County Sheriff's Office began their investigation as to that robbery of Mr. KEETLEY. They obtained a description for Mr. KEETLEY, that being of a Black female and 2 Black masked males, and a description of the suspect's vehicle. Law enforcement, as they do in all of these kinds of cases, began their investigation, working on leads that they were able to have, working off of the information that Mr. KEETLEY provided to them. And unfortunately, they were not able to make any arrests in that robbery investigation. They were not able to identify any suspects. And Mr. KEETLEY was upset about that. He was upset that he had been injured and that no one was going to pay for that. He was upset that law enforcement was not able to complete and close out that investigation with an arrest. So he decided he was going to do his own investigation. He was going to go out and speak to witnesses. He was going to try to obtain evidence. And as this case will unfold over these next several weeks, you will learn from numerous witnesses about what he did in his investigation. He spoke to people in the neighborhood. He conducted research, website research on his laptop. He obtained firearms. And as his investigation unfolded, word on the street was that Hispanic individuals, Hispanic males, were in fact responsible for the robbery, not the individuals, not of the individuals of the race that he ultimately had identified or had provided to law enforcement. And that he had uncovered these Hispanic males were the ones who ultimately had caused him harm and had robbed him. And as he is uncovering this information, as the word on the street provided him, that a person by the name, a Hispanic male by the name of Creeper, nicknamed Creeper, his name ultimately being learned was Omar Bayan, was in fact one of the individuals who had robbed him. And so when Mr. KEETLEY gets that information, you will learn as this case unfolds and viewing evidence and exhibits in this case, that he researched and spoke to people about Creeper. He told his friends, his girlfriends, look for Creeper, look for a man with the nickname Creeper tattooed on his arm. This is what he is telling his friends and his girlfriends over this 11-month period. And as he's conducting his own investigation, he learns that this Creeper man lives at 507 Ocean Mist Court. And why is that important? Because this horrifying incident that occurred on November 25th of 2010 was at the address of 604 Ocean Mist Court, just down the street from the home of this Creeper person. The defendant, you will hear from witnesses, enlisted his friends to help him in his investigation. Not only look for this Creeper, but he had a female by the name of Norma Jean Towers, who he had drive through this area looking for Creeper's driver's tag. The defendant covered his face up, wore a hat and covered his face up as he had her drive through the neighborhood looking for tags that he was going to be able to complete his investigation. He had offered a reward that he had signed, he had posted on his ice cream truck, offering a $5,000 reward to help him find this Creeper individual. You'll have testimony from witnesses that he approached a 13-year-old girl and interrogated her to tears, trying to find out information about Creeper. You'll hear that he hired his friend David Beckworth to be his muscle after the incident that had occurred in January where he was injured. And David Beckworth worked with him with the ice cream truck to help protect him and to help find this creeper. And David Beckworth had agreed to help his friend find creeper and take him down. The agreement was to dress up like cops, hunt them down, and kill them.
Well, that's a pretty serious
And
allegation.
as this case unfolds, you will hear testimony from witnesses. For example, Ms. Logan was going to tell you that those early morning hours of November 25th of 2010, David Beckworth wasn't with Michael KEETLEY. He was with her at her family gathering, preparing for the Thanksgiving Day, smoking a turkey. So although the plan was for David Beckworth and the defendant to gun down this creeper, Mr. Beckworth was not with Michael KEETLEY those early morning hours when this horrific incident took place on Thanksgiving morning. Law enforcement did continue to attempt to conduct their investigation. Mr. KEETLEY would take law enforcement, the leads and the information that he had, but he was not able to give them any witness names that they could go and gather an ultimate witness to say, how do you know Creeper was in fact involved in this robbery? And it was also concerning to law enforcement that he had originally identified a black female and two black males. And now he was saying it was a Hispanic males, one with the nickname Creeper. And this obsession with revenge is festering and festering from January
Uncle festering.
until November 25th of 2010. And you will see that from the evidence, from the laptop research forensic evidence. He looked up Bayan, who belongs to Omar Bayan, 11 times. He looked up law enforcement 22 times. He looked up Ocean Mist 92 times. He looked up Glock, as in the Glock firearm, 2,353 times.
Wow.
He looked up uniform.
You should be able to decide before at least the first 2,000 searches.
You understand why Glock and uniform become important. He looks up Omar 11,602 times.
That's all he does.
That's a little obsessive.
Yeah.
Let's talk about what happened those early morning hours of November 25th, 2010, approximately in the 2 hour in the morning time frame.
But just because he's searching stuff doesn't mean he's guilty of murder.
Wednesday night, the 24th, the day preceding Thanksgiving, into the early morning hours, the victims were friends, and they had decided to gather at 604 Ocean Mist Court because they didn't have to work the next day. So they were going to hang out, have some drinks, play cards on the front porch of Ocean Mist Court. And Juan and Sergio, Daniel Beltran, Gonzalo Guevara, Ramon Galone, Richard Cantu, Jose Rodriguez were all there hanging out that night. They were drinking beers, they were playing poker cards, and 3 of the victims did partake in drugs, in marijuana and cocaine. And you will hear that as they were sitting there on that front porch of 604 Ocean Mist Court, those early morning hours, they see a dark colored minivan come down the street, which was a little odd because it was so early in the morning, 2 a.m. So they notice the vehicle, and then it comes back towards the home and pulls up at the end of the driveway of that home. And as they are looking at the vehicle, as they are sitting there on the porch, as they had been hanging out earlier, they see a white male individual exit that dark colored minivan. And that individual is wearing a black t-shirt with a law enforcement name in white big block letters, either police or sheriff, across the shirt. And he has a gun in his hand. And so they are thinking, some of them that had the drugs that were still there, oh, there's law enforcement. They need to put the drugs away. So as this individual, this lone gunman approaches, who they believe to be law enforcement, who they believe to be a law enforcement officer at the time.
I'm sorry, I can just, here's a law enforcement officer. Guess we better put the cocaine away.
Wonder what this law enforcement officer wants of them. Well, this individual, this white male dressed in a black shirt with white block lettering, dark green and black pants, camo style pants, demands, where's Creeper? Where is Creeper? Who is Creeper? And has his firearm. These individuals, the victims on the porch, They know Creeper. They know Omar Bayan. But Omar Bayan that night is not there. He was not on the porch on November 25th of 2010. And as you'll recall, I told you his address, as the defendant had learned through his own investigation, was actually 507 Ocean Mist Court. But there were multiple Hispanic males out on that front porch that early morning. And as this gunman, who at that point they still think is a law enforcement officer, is demanding, where's Creeper? The law enforcement officer demands they pull out their identification cards to see if they're telling the truth, which they do. He tells them to get down, which they do. They get down on their knees. They pull out their driver's license. And Creeper, Omar Bayan, is not there. That's when, one by one, execution style, the defendant shoots the victims. This lone gunman is there, and when the first victim is shot, that's when they realize this is not a law enforcement officer. None of them have guns on them. None of the victims were armed early morning hours. And as you will hear testimony from the surviving victims in this case, you'll hear testimony as to what they remember. And you'll hear that one by one, they heard the shots of their friends in the backs of their bodies as they were kneeling on that front porch. You will hear testimony from the medical examiners in this case, Dr. Mary Malin, who conducted the autopsies of Sergio and Juan Guitron. And before Dr. Malin responds to that scene, you will hear that ultimately when Sergio and Juan Guitron are shot and killed, and the other victims are there, two individuals are able to flee from that porch, ultimately, after the victims were shot. You have Jose Rodriguez, who was there, who was able to flee and was never injured. He's the one individual that would never sustain a gunshot wound those early morning hours. And you'll hear from Daniel Beltran. He was shot multiple times, but he was able to flee once he soon realized that this individual who he thought was a law enforcement officer approaching that porch was anything but a law enforcement officer. You will hear that since they were unarmed, they were not able to defend themselves. You will hear from Daniel Beltran how he tried to get his friends' attention at the beer bottles that were just in front of them because he thought maybe they could use the beer bottles to defend themselves those early morning hours, as one by one his friends were being shot around him. The victims, the surviving victims in this case, will tell you there was one gunman and there was one gun. Ultimately, Sergio sustained one gunshot wound to his back. Juan Guitron sustained two gunshot wounds to his back. Each one of those taken individually were both fatal. Each one was fatal in and of itself. Richard Cantu was shot in the back of his head. And he, unfortunately or fortunately, however you look at it, has no memory of this incident. Gonzalo Guevara was shot 4 times, including in his back. Ramon Galan was shot on the right side of his body that traveled through his stomach and exited out the other side of his body. Daniel Beltran was shot 3 times in his hip, his chest, and had a graze to his face. And he was one that was able to escape. You will hear these victims testify about what they went through, what they observed, what they were thinking those early morning hours of November 25th of 2010. You will hear from them that they were rushed to the hospital. All of the victims were taken to hospitals or by ambulance or taken by air to the hospital, all but Sergio Guitron. He was left at the scene and pronounced deceased on that front porch of 604 Ocean Mist Court. Juan Guitron was later pronounced deceased at the hospital. And law enforcement began their investigation soon thereafter, soon after this incident occurred. They arrive on scene. They secure the scene. They learn what hospitals the victims were being transported to. They start documenting the scene, marking items of evidence that were left behind on that front porch and in the area surrounding that front porch, such as shell casings, wallets, driver's license that were left behind. Ultimately, they collect those items of evidence that were sent off for testing, and we'll talk about that in a little bit. Law enforcement conducts interviews of individuals that may have information about this case, and ultimately when the victims are able, the surviving victims, when they are able to provide a statement to law enforcement meets with them in the hospital. And they learn of a description provided by the victims. This white male, one individual with a black t-shirt with the white law enforcement lettering and the dark camo pants with one gun. The description that law enforcement obtained for multiple victims in this case. The dark colored minivan. And they learn of the identity that this individual had been asking for Creeper and had demanded to see their driver's license. Law enforcement learns Creeper's nickname is linked to Omar Bayan. They also interview other individuals such as Stacy Rogan, who when she hears about this incident the day after, Friday, November 26th, hears that multiple Hispanic males had been shot at over on Ocean Beach Court. She reaches out to law enforcement. And she tells law enforcement that she used to date Michael KEETLEY. And he had told her if she sees a man, Hispanic male with the name Creeper tattooed on his arm, for her to call him. Call Michael KEETLEY. Don't call law enforcement, call me, is what he told her. Law enforcement follows lead upon lead upon lead in this investigation. They speak to Mr. Guevara, who was still in the hospital, who had been sedated for several days after his injuries. And ultimately, Gonzalo Guevara,
He looks like the police captain from Police Academy.
You'll hear testimony about that. You'll also hear testimony from a prior hearing where Jose Rodriguez, who was not injured, fortunately, that night, but he also makes the identification in that hearing of Michael KEETLEY being on that porch, being the lone gunman, early morning hours of November 25th of 2010. All of this investigation that law enforcement is conducting leads them to the defendant, Michael KEETLEY, where they interview him on November 27th, just a few days after Thanksgiving. They interview him and they asked him if the word on the street is that Creeper is responsible for his robbery. What does he tell them? No. He's asked if he ever heard about a guy named Creeper. He responds, no. He's asked if he ever asked anyone else about the person named Creeper. He responds, no. You will hear testimony in this case, witness after witness that will sit in this chair and tell you all that Michael KEETLEY told them about Creeper.
Oh, she's getting animated. Theatrics!
In that interview, Michael KEETLEY also admits to law enforcement that he owned a Glock 21 that shoots .45 caliber. Why is that important? The shell casings and the projectiles left behind at the scene of 604 Ocean Beach Court are .45 caliber that were left around the front porch and under the front porch, which is consistent with what the victims had said, is that they were kneeling down or down on the porch when they were shot. The following day, after the 27th of the interview of Michael KEETLEY, law enforcement responds to the KEETLEY property, the KEETLEY residence. It is a huge property where multiple homes are located on. So on the 28th, law enforcement is continuing with their investigation. They have searches of the home, the property. They obtained numerous firearms. Mr. KEETLEY was an avid gun owner as well as his family. They obtained numerous firearms during the search of that home. There are shooting areas on that home and that property where there are items that were ultimately collected. Most importantly, a .45 caliber projectile near a van that had been used as target practice.
Okay, so it's like one of about a bajillion people that buy Glocks during the course of a year.
.45 caliber shell casing had been located. Multiple guns were recovered on the 28th during law enforcement search, except one important one, the Glock 21 that shot 45 caliber. A laptop was recovered from the KEETLEY home, as well as a composition notebook that was sitting on the kitchen counter. A composition notebook that on the first page, when you open it up, has Omar Bayan, 507 Ocean Mist written on it. Law enforcement collects that. Ultimately, testing is done on that composition notebook. Latent fingerprint is lifted from the inside cover of that notebook, as well as the page where Omar Bayan and his address is written down. That fingerprint is matched to none other than Michael. Let's talk about the evidence.
They have a fingerprint
that was sent off for testing that was ultimately collected from the scene, the projectile found at that shooting target on the KEETLEY property, and the shell casing that was found in that burn pit on the KEETLEY property, in addition to other shell casings that were obtained by law enforcement during this investigation. And they obtained other shell casings in this investigation from an acquaintance of Michael KEETLEY, who is Mr. Wesley Smith. Mr. Wesley Smith is a machinist. He and his coworkers would frequently buy ice cream from the defendant following his injury. And one day, the defendant engaged in conversation with Mr. Smith. And the defendant had learned that Mr. Smith is a machinist, and Mr. Smith will tell you that typically being a machinist and people who are into firearms are typically asked, do you work on firearms? Do you make any kind of modifications to firearms? And so Mr. Smith, being an avid gun owner himself, him and Mr. KEETLEY had this common ground and spoke about firearms often. And ultimately, one time, Mr. KEETLEY even invited Mr. Smith and his wife, Ms. Carmen Smith, over to his home, where they shot firearms together. Mr. KEETLEY fired his firearm, his Glock 45. Mr. KEETLEY allowed Mr. Smith to fire the Glock 21 that shot out 45 calibers. Ms. Smith was also there and observed all of this. And Mr. and Mrs. Smith picked up the shell casings after. They tend to recycle them. And also they were concerned about the livestock that were on the property, potentially getting into those. And so when Mr. Smith was interviewed in this investigation, he had told law enforcement that he and his wife, when they had previously been to the KEETLEY home a few weeks before the incident on November 25th of 2010, that he had shell casings from that shooting get together. And he provided them to law enforcement. He didn't know if they would be helpful. So ultimately, you will hear from Jennifer Clark, who is an analyst with the Florida Department of Law Enforcement, which is an accredited lab that conducts ballistics examinations. And it's not just looking at a shell casing and looking at another one from the eye and saying, oh, they're both Winchester, they match. This is microscopic comparisons done by an individual who is trained. And
I believe Steve will have comments about this at break time.
Comparing one to the other and making a determination at these markings that are placed on the shell casings when the bullet is fired, when it ejects out of the firearm, comparing those, as well as comparing markings on the projectile that is shot through the barrel of the gun. She looks at the markings left on these pieces of evidence to make determinations as to whether or not they came from the same firearm, and sometimes if they came from a particular firearm. So you will hear testimony that she had projectiles from the scene in this case, 45 caliber projectiles that were recovered from the 604 Ocean Mist Court. She had shell casings that were left behind at 604 Ocean Mist Court. And that she determined that those shell casings all matched as having come from the same firearm. And that the projectiles that were left at the scene, the 45 caliber projectiles, all came from the same firearm. She ultimately also compared the shell casing from the burn pit off of the defendant's property as matched.
What is with
shell
people in
casings
burn
from Ocean Mist
pits?
Court.
Come on.
And that the projectile from the shooting target on the KEETLEY property matched the projectile from the projectiles at Ocean Mist Court. She is not able to say if they in fact came from the Glock 21 that Mr. KEETLEY owned, because that was never recovered.
Again, we have
She will also tell you that the shell casings
forensic evidence
matched coming from a Glock. She is not able to tell you that the projectiles came from a Glock. How is that possible? That is possible, and as the case unfolds and the evidence is presented, that if someone changes the barrel, places a aftermarket barrel on the firearm, it won't, and it's not, if it's not a Glock. So basically you have a Glock firearm, you change the barrel to an aftermarket barrel. Those projectiles will not match as having come from a Glock because it's a change that has been made. And when ballistic comparisons are done, firearms are very specific and unique, and they make unique
No, that's false. That is scientifically false.
Projectiles and shell casings.
That is not.
So if something has changed,
disprovable. This is
from
BS.
being the manufactured barrel on the Glock to an aftermarket barrel, they're not going to match.
We deal with this. This is FDLE. We getting this. Yeah, right.
You will hear also testimony from the victims.
We got to
in
deal with
case
this FDLE. This is why I'm
when
on my
they
5 horsepower.
observed this firearm, they all describe it as a long gun, not a short gun that a Glock is. A Glock is a handgun. They describe it as a long gun, which they describe also as they saw a pump action done by the gunman when he approached the porch and when he began shooting.
A pump action
Victim
long gun?
victim after victim. You will hear, since Mr. Wesley Smith and Michael KEETLEY had this love for guns, that they spoke about gun shows that they would go to. They spoke about attachments that can be placed on guns. They spoke about modification kits. A modification kit that was new in 2010 that Michael KEETLEY spoke to Mr. Smith about because it was going to make it easier for Mr. KEETLEY to shoot the firearm, because after he sustained his injury from the robbery, he could still shoot a firearm, as you're going to hear testimony from the witnesses, just not as easily as he could before that injury. And so you will hear that this modification kit that Mr. Smith and Michael KEETLEY discussed is a modification kit where a Glock is slid up into this.
We object. We approach. Yeah.
There we go. We've got our first little thing here. When she finishes, we'll read the super chats that have piled up here. Let's I'll say I like this how they do that here. This is kind of cool. So he gets to hear what they're talking about. We don't, so we'll fast forward through it here. So we'll get the super chats and answer the questions when she finishes, which should be
testimony throughout
in a
this
while.
case about conversations that Mr.
Just a
Smith
few
had
minutes.
with Mr. KEETLEY regarding
Yep.
firearms. In addition to all of the ballistic evidence in this case, and how I previously discussed with you how the aftermarket barrel could be attached to a Glock, and how that projectile, Miss Clark cannot say came from the Glock. You will also hear evidence in this case that multiple searches were found on Michael KEETLEY's laptop computer regarding aftermarket barrel attachments. As law enforcement continues on with their investigation after conducting multiple interviews, collecting multiple pieces of evidence in this case, following lead after lead, sending evidence off ultimately for testing, they also learned that the day after the shootings, Michael KEETLEY takes his father's van to be painted, to have the color of his father's dark colored minivan changed. So on November 26th, Michael KEETLEY makes contact with Mr. Henry Bose. Mr. Henry Bose, who lives in Tarpon Springs and conducts a car painting business out of his home. And Mr. KEETLEY arrives at Mr. Bose's home. Mr. Bose is not there, but Miss Carrie Bose is, and she was not expecting Mr. KEETLEY that day, the day after Thanksgiving. And she usually, if customers are going to be coming to their home, since the business is out of their home, Mr. Bose will tell her when customers are going to be arriving. Mr. KEETLEY arrives at their property with this dark colored minivan that is all solid dark blue. Mr. Bose is not there, so Mr. KEETLEY proceeds to clean out the inside of his van. Even though the inside of his van is not going to be painted, the outside of his van is going to be painted. He cleans out the inside of his van, where multiple bags of trash are taken out and placed where the Bose family keeps their trash. He then also begins to wash the outside of his vehicle that's about to be sanded down and painted. And he assists Mr. Bose in all of this. He assists Mr. Bose in sanding down the vehicle with a handheld sander. And he and Mr. Bose work until the late hours, going into Saturday morning. And Mr. KEETLEY stays there and helps him work on this vehicle. He doesn't drop the car off, go home, and come back and pick the car up when it's needed. He stays there all night. He, in fact, sleeps on the couch waiting for the vehicle to be done. And the plan was to change the vehicle color. It was going to become no longer one solid color. It was going to be two-toned. So it was navy on top and it was a tan bottom.
Oh.
And this was done the day immediately preceding the shootings. He, in fact, wakes up Mr. KEETLEY and unwraps the vehicle himself the next morning after he was done sleeping at the Bose home and after he had completed helping Mr. Bose with the job that he had hired him to do. Ultimately, ladies and gentlemen, the surviving innocent victims in this case will take the witness stand and tell you exactly what they remember happening to them those early morning hours of that Thanksgiving morning, that the pieces of evidence that were seen at Ocean Miss Court corroborate the victim's statements, that there was one gunman with one gun, and those projectiles matched a projectile taken from the defendant's property, and those shell casings found at Ocean Miss Court matched the shell casing in the burn pit at the KEETLEY property, and that the defendant was obsessed with getting revenge on the individual that he thought robbed him. He was going to get revenge on November 25th, 2010. And the state's confident that at the conclusion of this case, you will find the defendant, Michael KEETLEY, guilty as to all charges. Thank you.
Thank you, Mr.
I hope the defense has got the did a Daubert motion to challenge that BS tool marking science, which I've been posting into the chats, and I posted into private chat also. The science, this is the thing. Somebody is going to go away who is innocent based on this fake tool marking stuff. I'm sorry, it's not, they cannot say what she's saying that they can say. And I've dealt with it. Florida Department of Law Enforcement does this all the time. They have these people that say that this shell casing was fired from exactly the same gun. Garbage on that, because you cannot disprove that. It can't be disproven. If there is no null hypothesis, it is not science. And it's not just me. It's not only Tobin and Blau, which are two of the leading experts who've written a very good academic paper on it. It's also the National Research Council. It's also the President's Council of Advisors on Science and Technology. You know, these are the leading authorities on this forensic science. And what she is saying that they have as evidence of guilt is is based on a premise that is false. And that is that you can take, by examination, you can determine whether this shell casing was fired from this particular firearm. That's garbage. Have you seen the production lines on a Glock factory floor? You know how
they probably make a good few million a year, I would imagine.
Each one of these is little bullets, is polished. Each one of these pins is a unique identifying thing. Are you kidding me? That is such garbage. Anyways, you know my stance on this. I've ranted on this before, and here we see it yet again.
Well, there's a good follow-up question. Then why do judges allow it?
Because, well, number one, did the defense attorney challenge it? Sometimes they just accept it. They need to challenge it in what they call a pretrial Daubert motion, Daubert versus Merrill Dow Pharmaceuticals, which they need to pretrial exclude it based on faux science, number one. And if it's private attorneys, a lot of times if they don't have the money to do it, they're not aware of the issue. This is why I preach on it, because they need to be aware of the issue. They need to challenge it. Some judges have excluded it. Federal courts, they exclude it regularly. So that's number one. Number two is, it's like, well, I'm going to allow it. It's a credibility question. You can do that on cross-examination. But that's the whole point of Daubert. Daubert is supposed to pre-screen fake science, because it's like, well, why don't we just have the horoscope person or the palm reader come in and says, well, his palm shows that he's a liar, right? Well, because it's faux science. You Daubert challenge that and say that's not scientific, and you need to not let the jury. You don't throw your hands up as a judge and say, well, I'll just let the palm reader testify because, that's a credibility question. The whole point of the Daubert screening process is to keep faux science from getting in front of a jury. And here we have it yet again in another trial. It's a close case. And all of a sudden you've got a close case and well, it seems pretty determinative. It's a match. That's convincing, right? When they can't say that. It's, it's the same thing with bite mark evidence. This Chris Fabricant did a great book, Junk Science and the American Criminal Justice System. And this book talks all about bite mark matching. Chris Fabricant, excellent book if you want to learn. And there were people that spent decades and decades and decades in prison based on this science of bite mark matching. And it got debunked, and they found people actually innocent. People sat decades on in prison. It's really sad. Here, let me show you. I'll put it. We want to put a face behind it. Yeah, see here, look. So here's the bite mark, right? Look, there's the bite mark. We can match that up. Gave it on teeth. And let me see. Here's our guy. Here's our guy right here. See this fellow right here? The smiling sailor? That guy spent 3.5 decades in prison for a crime he did not commit. And he was released only after exoneration by DNA analysis. See this guy?
He does have a good set of teeth.
That did it.
It's a very lovely set of teeth.
Keith Allen Harward, if you want to look him up. Keith Allen, Harward. So why do I get passionate about fake science getting in front of juries? Because this is how innocent people get convicted. Now, I don't know what all the evidence is in this case, but don't let in the BS evidence.
Funk Mabona says, is this a retrial? If so, why? It is a retrial. All I know is the first jury was hung jury with reportedly 10 in favor of acquittal and 2 for conviction, which leads into the next question. Why was he in jail for so long? It's been 13 years since the murder. Well, 12 and a half years since the murders were committed, because it takes a long time to go to trial, first of all, and then he had the hung jury, and then we had COVID. So, and that's essentially the timeline as far as I know, which I don't know a lot of details about this because I wanted to go in this with knowing as little as possible before it happened. But that's all I know about it. Let's go. Brandon says, don't be lazy. Stream live on Rumble. You can play it on your phone in the background, which your boy likes. You may even get more subscribers or even a 1000K play button. Why are we going to race? Yes, streaming on Rumble is not something that's viable for me because I never look at it while I'm streaming on YouTube. And also I can't get any revenue from the Rumble stream because of banking laws in Korea and my tax situation. So yeah, that may change at some point in the future, but for now, Rumble is not a viable option for me, but I use it as a storage facility in case something ever happens to my YouTube channel. It's me, Josie81 says the Zachariah Anderson trial did me in. If this jury doesn't follow the law, I'm gonna lose it. Well, we hope they do.
And I will say that I've been through enough cases. I've been through probably a number of cases that are actually innocent that have been convicted. And I've been through I've seen a lot of cases that they're not guilty beyond a reasonable doubt. And, so I'm kind of down the road from where you guys are. I'm kind of glad that we're publicizing these trials because people will see that these prosecutors are, when they misbehave and they're playing these games, that there are innocent people and there are people that the system is really broken. And don't put your faith in the criminal justice system. I really am. Mm-hmm. That's a good thing in one ways. On the other, it's like, welcome to my world, right?
Matthew Self says legal vices. Most people in rural areas have burn piles for tree branches old. But I know we have a burn pit. We had before my dad went to the retirement community. We had a good old burn pit out in our house out there in rural Utah. But it's like everybody in the last several trials had like burn pits that have played into the trials. People stop burning stuff. Just saying. Let's go, Brandon. You will hear that I'm an idiot. The prosecution's opening statement. And also, let's go, Brandon. The script I wrote and reading said, get animated, get wrecked. If I paid $1,000 an hour for a lawyer and they didn't memorize the opening, well,
No, I don't agree with that. I do everything by notes, little yellow sticky notes, but you have an outline, so you want to make sure that you hit the points that you outline. I don't.
Well, you saw the opening to the Gwyneth Paltrow hearing where the guy completely read that, didn't you?
No, I didn't. I didn't see it.
Oh,
I'm sorry.
No, I mean it was like
I only watched the Gwyneth Paltrow testimony a little bit
Yeah.
beforehand. That was
the,
exciting.
the opening statements are painful. I mean, he's literally reading it. He has his binder in front of him reading it, and he's reading it like on about a third grade level, very slowly, sounding out the words, and then he gets lost and repeats the exact line. Oh, it was bad. It was really, really bad. Go Utah lawyers. Duncan, Idaho. That seems like one of those Daryl Brooks varieties of innocent until proven guilty, given the circumstances. I mean, the thing is, you should be, if it's an effective opening by the prosecution, you should be walking away from the opening going, "Huh, sounds like he did do it." I mean, if you listen to the opening and go, "Yeah, there ain't no way he did that," then the prosecutors completely failed. But we've only heard one side of the opening, and that's not even this what you heard isn't evident. You should be thinking, well, I mean, if the prosecution did a good job, you should be thinking, well, maybe there's something to this. So, let's see what the defense has to say, and then let's look at, more importantly, what the evidence shows us. Ms. Kay Griff, legal vices. The medical examiner in this trial was also a witness in the Jensen trial in Kenosha. I don't know about the Jensen trial. I don't know what the Jensen trial was in Kenosha. That was also a retrial. First was overturned. Schrader was the judge. Medical examiner also did a fake study. Lol. Oh, that should be interesting. And again, we're going to try to keep this as spoiler free as possible. Let's avoid spoilers in testimony as much as possible. How many murders, victims? Well, we don't know if there were any murders, but there's 2 people that were dead and 4 that were wounded. So,
well, except they were execution style, so we're definitely murders. Yeah, the question is who did it, right?
Well, we haven't seen evidence they were execution style yet. Just the people who were there to test.
Well, except that they're shot in the back of the head.
Let's see what the evidence says, Steve.
Okay, I'm just guessing.
Be a good defense lawyer. Yeah, they were probably murdered, but
the defense is identity. The defense isn't that they killed themselves, right?
We're coming off the Zachariah Anderson double murder conviction where it wasn't even proved the guy's dead. So I'm having a very healthy skeptical approach to anything that anybody says regarding death at the moment. Wendy C., why is it taking 10 years? Did I hear that right? Yeah, I kind of explained that as best we could. Duncan, Idaho, again, I think every prosecutor, thank you so much for the super chat again, by the way, Duncan, Idaho. I think every prosecutor there is the belief that they could have made it big in Hollywood if they'd really wanted to. Yeah, she gets randomly got very animated at one point and pointed off towards the defense table. Randomly for no reason. It was the only time she did it during entire opening statement, so it was kind of odd. Olive Dane, oh, what a cute dog. Why are there children sitting in the gallery? Is this normal for a murder trial? I don't know if I'd let my children sit in a gruesome 4 murder, 2 murder and 4. Let's see, there I go, assuming murder. 2 murder and 4 near fatal woundings, but could be his grandchildren. They could be family. I don't know. I just it's not abnormal, is it, Steve? I mean, it's just family or for friends or.
It's kind of tough. I mean, that's a call. It's an individual call.
And I mean, you'll see, especially if there's children that are victims, you'll see schoolmates and whatnot show up for solidarity and things, or civics. I don't know if they still do field trips in school, but we saw a court case in on a little field trip. I remember in elementary school.
I love you remember Fast Times at Ridgemont High when he goes and he's like, "You're not in my class." And today, neither going to watch the autopsy.
Trent Thorough, Jeepers, it's the creeper. Yeah, it's see, if you're gonna do something, you probably don't want to have multiple searches for the word creeper in your browser. It just looks bad. And John Gordon, thank you so much for the super chat. Better to have a hung jury than a hung cellmate. Yee, okay. I guess so. All right. We've got the opening statements here lined up here. So we're all caught up on the super chats. Thank you so much for all those super chats there. 10 years, even if he's found innocent, the justice system has already failed. Yeah, those are 12 years of his life he's never going to get back. You know, if you don't like ice cream sandwiches, I don't even want to know you. Okay. For some reason, as a kid, I didn't like ice cream sandwiches. Now I do. But anywho, oh, and we have a couple of other things I forgot to mention here. Where'd it go? Our Chaos Coordinator gifted 10 Legal Vices memberships. So if you were one of the 20, I'm sorry. Wow. 2 separate times, Chaos Coordinator gifted 10 Legal Vices memberships. So if you were one of the lucky 20 that got Legal Vices memberships, please give Chaos Coordinator a big thank you for that. And thank you for your generosity. And we also had, I don't know if you're listening, Chandler, but earlier today in my time, you joined the Clean and Sober crew. I just saw that message at the top of the screen. Thanks, Chandler. Now, when you get members on your stream, I'll have to join yours as well. So thank you very much for all that generosity, Chaos Coordinator. All right. That's it. Has he been in jail all this time? Yeah. I mean, the murderers, alleged murderers, accused murderers, especially those that are accused of murdering 2 people and wounding 4 others, either never get bail or Florida is a right to bail case state, right, Steve?
Well, yes, but there's some they're not in a murder case.
And then even if they do get him, it's like, okay, well, you're allowed bail. We'll give you bail. Cash $4 million. You know,
yeah,
like
it's ridiculous. So no, in certain, there's 2 reasons you won't get bail. One is, well, maybe 3. One is if you have a murder charge or a charge. Also, is that something called the Anti-Murder Act, which is if you're currently on probation for a felony, commit a new felony, and then there's and then of course if you don't show up for court and your bond is revoked, then you can't get a new bond. So.
Anti-murder. Is there like a pro-murder statute?
No, it's called the anti-murder. You know, somebody committed the way these things, they all have a history behind them. Somebody was out on felony probation or something, and then or felony bail, right? They were already out on bail on a prior felony, and then they go kill somebody, right? So then they call that the Anti-Murder Act. So that if you're already out on bail on a felony, they're not going to give you a new bail on a new felony, right?
Well, like people picketing, holding up "I'm pro-murder" signs in front of the courthouse. Let's go, Brandon. 261 more likes, or Jeffrey shuts the stream down. Oh, are we doing that good already? Wow, we do have 741 likes and 966 concurrent viewers. We have nearly 1,000 on this replay. And for those of you that joined late, this is what we're going to do. This was a neglected trial, and because of Anderson and because of Paltrow's thing going on now, so it didn't get a lot of attention and love. But people said it's very, very spicy at times and is very, very captivating. And a lot of people asked. So I decided I'm going to go through this and we're going to watch it. We'll watch morning one day. We'll watch the afternoon the next day. It was a 10-day trial. So it'll take us about 3 or 4 weeks to get through the whole thing. If interest stays up, we'll continue going through it. If in the midtime people think it's a waste of time and people stop watching it, then we can just cut to the chase and go straight to the verdict. I'm good either way, but I think it would be great to see this, watch it, and we'll see how it turns out. The jury's actually deliberating right now, so we'll know what the result is before we get anywhere near the end of this trial. So we're just doing this so we can make our usual commentary and give you my thoughts on it. And whenever Steve has the chance, he'll join us. Just kind of let you know what we're thinking about it and see if ultimately we agree with the whatever the jury decides in this case. So thank you for joining, and let's keep going here. We've got the like and subscribe poll. How are we doing so far on that? It's super lame. Right now with 20% of the vote, I crushed the like and subscribe buttons to vote yay. I have something to do now. 32% of you said I crushed the like and subscribe buttons to vote let's do this trial. And 48% of you said you crushed the like and subscribe button to vote let's get Steve Gosney on here. Well, as you see, the voice of the people has spoken.
That succeeded. I'll say that's the reason I clicked yes on your invitation today. I'm kind of working. I'm sort of got my one ear out, so if I'm half paying attention, but it's interesting. I like listening to you guys.
So that's what we're doing, and there is no requirement to super chat, no minimum requirement. We pull up regular chats as we see them as they get noted, and we have time to talk about them as they're relevant. But all of the super chats, because whether it's a 99-cent sticker or a $500 super chat, it's all the same to me because it represents you parting from your hard-earned cash to support me and to support the channel. So I read everything that comes through, and it's you know, that we do the grift one day a month, a hardcore grift, which we'll talk about maybe a little bit later. But the rest of the month is all just kind of gravy, and I treat you with respect for parting with your money. So it's not required, but I do guarantee you I will read and respond to every super chat eventually. And with that, let's jump into the defense opening statement.
And I will say, though, just so that
yes,
I'm usually very much engaged in the chats, but I'm not as engaged in the chats because I'm actually working right now. Because I'm doing something that doesn't require me to, so I can listen and then visually read and write at the same time, but I can't interact with the chat as much. So so just so you know, because I am working hard here, but I've got an ear cocked out for what you're doing. So good job on you guys.
Is there a K bar in this case? And did
There
Steve
is.
do it?
I'm
Do
just
you have a
saying.
Glock 21?
Glock? Not that I admit to.
Used to be around here somewhere. It's like I like the G. Gordon Liddy when he was talking about how all the firearms he has around the house. People are saying, "Do you own any guns?" He's like, "No, I'm a convicted felon. I own 0 guns, but Mrs. Liddy owns about 27 of them." All right, and one last thing here. John Gary, retrying after a hung 10-2 in favor of an acquittal is an interesting choice. Could this be a political thing?
And no, the answer is I would not get this case. It is a Florida case, but it's in Tampa, and my jurisdiction doesn't cover Tampa. It covers Jacksonville down through Daytona, Melbourne, that area.
If he was possible to get this case, he wouldn't be sitting here right now.
Exactly.
Okay, so I need to give you less money. Got it. No, that's not what I was saying. I was saying that your $500 chat hint is the equivalent to some people of a 99-cent chat. That's all I was saying. It's an equivalency thing. Anyway, let's go. Oh, crap. Right. Defense lawyer. Wait, did I go too far? I went too far, didn't I? Boop, boop. There's a judge coming in. And watching the jury come in. Peter Griffin waiting for the...
Discuss anything about the case during the break by show of hands. Let the record reflect there are no hands. Again, thank you all very much. We'll now turn to the defense.
All right. What's the defense going to show us? Or tell us? The jury doesn't have to show us anything. And keep that in mind. That's actually a very important thing to keep in mind. The jury has to prove absolutely nothing. They have to show nothing. It is completely up to the state. They have the burden of proof. They have to discharge it. But I have a feeling he's going to tell us why the prosecution is wrong.
I told you we would have a response. Okay, here it comes. But first, let me tell you what we agree with. We agree with the government when they say that on November 25 of 2010, a terrible crime occurred here in Hillsborough County. And we agree with the government when they tell you that Juan and Sergio Padron died.
Okay. Now they're established they're dead and murdered.
We agree with the government when they come and tell you that it was wrong and it was criminal. But they say Michael Keetley did. They say Michael Keetley is responsible. They have picked up the heavy hand of blame and pointed it at Michael Keetley. Folks, that is where our agreement ends.
Already like this guy.
Michael Keetley is not guilty because he did not do it. Now, you just heard from Ms. Johnson for some time, and she told you some facts, and this is my chance to tell you what we believe the facts will be, okay? And we take issue with some of the things that they mentioned in their opening statement. And we take issue that there are some things that they did not tell you in this opening statement. And for that, great.
Did I say the jury doesn't have to prove anything? Damn it. I meant
We went
defense.
last
The
week,
defense
long
doesn't have
time
to
in
prove
jury
anything.
selection, and when we did, we talked to you about this idea of presumed innocent. But when you sit here, you are presumed innocent. And at some point it was suggested unless the
Ooh.
government proves its case beyond to the exclusion of each.
I swore I wasn't going to stop this and we were going to treat it like a regular trial, but I like that. You are not innocent until you're innocent unless. I like that. I like that statement a lot. Cool.
Each and every reasonable doubt. Remember how we talked about the father who presumes that his son or his daughter did something without seeing? And then we said, we don't want to presume guilt in any situation. It's not fair to start here at this table.
Oh,
Remember how we said as a father or a parent that maybe we'll stand here in the middle.
I'm going to jump into argument after opening statements.
I'm going to caution Mr. Grant not to argue the case. Save it for closing. Let's talk about
Yeah.
what you believe the facts of the case.
As you hear the evidence, you don't stand in the middle. As you hear the evidence, you are to presume that he is innocent. And Michael KEETLEY is here today to let each and every one of you know that he is not guilty of what these prosecutors say he is. So let's get to work. When we talk about this case, the government will have to prove their case beyond and to the exclusion of each and every reasonable doubt. As you have heard already in jury selection, a reasonable doubt can come from a lack of evidence, a conflict of the evidence, and the evidence itself. When you hear the testimony today, you, and throughout the time we're together, you can, and you should, consider what's missing, what conflicts, and what you hear. And as you do, the courtroom will fill with reasonable doubt, even though it only takes one doubt that is reasonable. In bringing these charges, the government has the obligation to prove every element of their crimes. Michael KEETLEY has to prove nothing, but we have stuff to say. Michael KEETLEY stands here ready to face what they bring. They have to prove.
I'm just saying at this point, Mr. Grant, let's move on to what you believe the evidence will show. Let's avoid any argument in the opening statement.
Sure. Sorry, Judge. The evidence will show that they have to prove every element of the case, and they have to do it beyond a reasonable doubt. So before we get to Thanksgiving morning of 2010, we have to go back in time. The prosecutor argued that this is a case of obsession.
acid rain, I'm sure.
Vengeance and revenge. We need to tell you about January 23rd of 2010. For while they said it's evidence of his motivation to commit a terrible crime, in reality, the evidence will show irrefutably that he could not do what they've accused. On that day, Michael KEETLEY, as he had many times before, drove his purple ice cream truck throughout Ruskin, throughout Waimama, throughout Old Sun City Center. Michael KEETLEY was known. Michael KEETLEY was known. That Ocean Vista dress, he'd been up and down and around that many a time. On this January 23rd, what happened was someone flagged him down, a woman, and he stopped. Do you want ice cream? Do you want nachos? She wanted his money. And she had two people to help him get it.
Ice cream and nacho truck. I like that.
They did not tell you that the people who put a gun to him were wearing ski masks. And they did not tell you that all he could see was their eyes. They wanted everything. They gave him everything, all $12. And then they shot him. And then they shot him again. And then they shot him again. And then they shot him again.
4 times? Jesus.
I don't think it's even possible to explain or understand how Michael KEETLEY was able to get to that driving in the driver's seat.
Well, Mr. Grant, rephrase.
Fine. I don't think the facts will show exactly how he got in that driver's seat and was able to drive himself to safety.
I like this guy.
Yeah.
That was exactly the way he dodged that.
And somehow he got taken to Tampa General Hospital. Michael KEETLEY arrived with shots to his leg chest, shoulder, and hand.
Dang.
No one wants to be in the condition that Michael KEETLEY was on January 23rd. But if you are, you want to have David Halpern on call. David Halpern is the chief of plastic surgery for Tampa General Hospital. David Halpern was on call. David Halpern operated on Michael KEETLEY on January 24. David Halpern has a specialty in the area of the hand. And what the prosecutors did not tell you was the extent of the injuries. David Halpern is going to come before you on March 14th. And Ms. Khan is going to ask him questions. And Ms. Khan will help guide Dr. Halpern to educate you on what was going on with Michael KEETLEY, what his condition was, specifically and especially as it related to the hand. It's important for you to know that as a result of what happened to him on January 23rd of 2010, Michael KEETLEY was left with a pronounced left leg. And the hand, they're going to use a word called comminuted fracture. Basically, that means when the bullet goes in, it just doesn't break in one or two places. It is the worst kind of injury. Sometimes you can't even put the bone back together again. And there are nerves that are attached. And Michael KEETLEY went through his first surgery on January 24, 2010. It would not be the last. He would have surgery again in March. He would have surgery again in June. You're going to hear a phrase called radial nerve palsy.
I had that when I broke my arm and my rib.
Yeah. Radial nerve, which goes from your shoulder through your arm, down to your hand, to your fingers and your thumbs. It wasn't working properly.
Yep. I had that for 9 months after my motorcycle accident.
And that really the only thing that could be done was
I can be an expert.
If there would be some response over time. The radial nerve, as Dr. Halpern will tell you, is the only nerve that allows us to extend our wrist, our fingers, and our thumb. Without the radial nerve functioning properly,
I still can't get this finger back all the way because of the radial nerve damage.
Without the radial nerve functioning properly, a person cannot extend their fingers. And without the radial nerve functioning properly, a person cannot extend their thumb. The question will be asked, Dr. Halpern, was the injury to Michael KEETLEY's hand significant? This will be the answer. It was majorly significant. It was majorly significant. So what does this mean? Dr. Halpern will tell you that what this means is that he did not have function to be able to do this. He could not. The only thing that could be done were some exercises to try to see if he would get some use, but that was over time. Here's a picture that Dr. Halpern will give you. He will say when someone goes into a room and turns on the light switch and the electricity doesn't go and the light doesn't turn on, that can be frustrating if you're entering a room. It can be very frustrating when it's your hand. The light switch will flick, but nothing would respond. Every 3 months, Michael KEETLEY would go for a test. A big fancy word will be used. EMG. I'm going to give you the letters because I have a hard time pronouncing it. It's a test that cannot be faked. It's a test that cannot be cheated. It cannot be gamed. Michael KEETLEY would have electronic stimulus put on his hand and his arm.
Oh, I
and
did
they
that.
would see if there was any response. The last test done on Michael KEETLEY November of 2010, November 1. The results, no recovery, no improvement since the last one in June. The switch is being flipped, but electricity is not going through, and the light is not going on. That's Michael Keetley. Medically. Let's talk about what you'll hear happen. When Michael Keetley got out of hospital in 2010, his life had changed. He could no longer live on his own. He moved in with his parents. He slept in a hospital bed. He wore Velcro shoes because he could not tie his shoes. He could not cut his meat. He could not always wipe himself. This is Michael Keetley.
There's a dog in court.
In order,
Yeah, how y'all hear my dogs? He's like in the other room across the house.
he has to think about it. Brushing his teeth requires thought and planning. Things that are taken for granted do not happen. Now, I'm going to tell you, there'll be a couple of people probably come in, a couple of ex-girlfriends. They'll say, we didn't really notice anything. David Beckwith, Wesley Smith, heard about one, and you'll meet the other. Yeah, he was shooting guns. They'll say everything was fine. Directly conflicting the medical testimony. Hear me, please, and hear me clearly. Dr. Halpern has not gotten a check. Dr. Halpern is not paid.
Judge, I'm going to object to this argument.
I was just saying, Mr. Grant, avoid argument. Just talk about the facts.
The evidence will show that Dr. Halpern was the treating doctor of Michael Keeton. Not looking over anybody else's work.
I didn't know Michael Keaton was involved in this, though.
Over and again. Because see,
Yeah.
the right hand
It makes it more dramatic,
and the
apparently.
left hand have to work together. He cannot do things separately and independently. That's what Dr. Halpern will tell you. In order to do this, he first must do this. And when he's got his hand open, he now must, I'll move it over here. He now must do this. That's Michael Keetley in 2010. The hand is not his only disability. All of this is going to be important for you because you're going to have to realize that medically, irrefutably, the evidence will show that his movements are slow. They are deliberate. They are awkward. They are uncoordinated. Spoiler alert, like nothing any of these people on the porch will describe. That's Michael Keetley. Furthermore, Michael Keetley had been in that neighborhood. So this is our defense. Michael Keetley is not guilty because he did not do it.
That's a good defense.
He could not do it. He is not medically capable. So now let's talk a little bit as the calendar is turned and January becomes February, and Michael Keetley is a motivated victim. There's no question about that. I expect that we'll talk to Detective Nolan, and when we asked Detective Nolan, he wanted to know who did this. He was shot. He was left for dead. He called, and he called. And you know what? What they told you the evidence will be is not correct. Michael Keetley described the people who did this as black, dark complected. The prosecutor, the detective, never once considered that Hispanics can be dark complected or light complected. And when Mr. Keetley called them, he was saying the word on the street is that this was Hispanics who did this. Ruskin, Waimama, Old Sun City Center has a heavy Hispanic population. Michael Keatley never once backed off of his identification. He said, this is what I'm hearing out there. Will you please go check it out? And without question, you will learn that Michael Keatley wanted to have the person who did this to him caught, not killed. Crime Stoppers was involved. Rewards were offered. He put it on his truck as he drove throughout Ruskin. Do you know? Have you heard? What have you seen? That will be the evidence. He was motivated. He was interested. And when he heard something, he called. And when he called, they did nothing. Nothing. He gave them names. He gave them anything and everything he had. And you know what they said? Stop interfering, sir. Let us do our work, sir. And to some extent, as the evidence will come out, and we'll ask Detective Nolan, the reason why you do that is you don't want to pollute a victim or a witness. You saw what you saw. Let's not use word on the street. Let's not use something that could contaminate you. To a certain extent, we can understand that. They told you that Michael Keatley was angry. They did not tell you the whole truth. Yes, Michael Keatley, the evidence will show, is that guy. You want to buy a nacho? Have you heard who shot me? He was preoccupied with that. There's going to be no question. They'll put a TV story on it where he says, I want the people who did this to me to suffer like I did. He'll say that. And he'll even say in a statement with Detective Schramm, we'll talk about him. Detective Schramm, you know what he says? I went through that. I processed that. That's in the rearview mirror. You may hear from a guy named Luciano Alonso. He's got a restaurant. Michael Keatley eats there. They talked. Nobody ever called. No evidence will be brought to say he's out there threatening people. If they produce someone by the name of Armando Guerra, listen very closely, because Armando Guerra will say, if he testifies, that Michael Keatley said I was involved with the shooting. Do you know what Michael Keatley did? He held out his wrist. He held out his hand. He said it doesn't work anymore. This is what happened to me. Not once will there be a threat. Not once will there be a weapon. Because you know what the evidence is? Michael Keatley is Ruskin. Michael Keatley is Waimama. The state's own witnesses will tell you that the people of Ruskin were fond of Michael Keatley, and Michael Keatley was fond of the people of Ruskin. You want to run a tab? Okay. You want to pay me back slowly? If at all? Okay. Over and again, Michael Keatley had involved himself in the community. That's the evidence. He was there all the time. That is very significant to this case. Oh, and by the way, you know what one of the other emotions he expressed was? I thought I was going to die, but I feel like God gave me a second chance.
Objection, Judge.
Wow, let's take this quick little break here to read the one super chat we've got. I keep hearing Michael Keaton, as do I. But that just makes it more exciting. I like his delivery so far. It might be a little too much now.
A little much, but he's passionate, and we'll see.
I was going to use the term
I don't
animated.
Like the prosecution's a little too aggressive on the objections, I would say.
Mm-hmm.
It's a little. He needs to. You got to be yourself, and this is who this guy is. Let's see how it unfolds.
And having lived through that radial nerve injury, I can say a lot of what he said is true. The one thing, it's a different nerve that handles the contraction of the hand. So I'm not buying that as a radial nerve injury. You can contract your hand, but you can't release it. So I could pull a trigger. I just couldn't release the trigger. So but again, he was blasted in the hand. So that could also affect it. All right, let's fast forward to the last little bit of this. And thank you for that super chat. Any more comes in, we'll read them as they come in.
When he was talking with Norma Towers, he thought that he'd been given a second chance by God. If they're going to bring in evidence in this case that suggests that it was all anger all the time, that is not correct, and we will confront that. They talked to you about Creeper. And they talked to you about that being Omar Bailan. Never once was the name Juan Gatron, and never once will there be any evidence that Juan Gatron was a part of what happened to Michael KEETLEY in January of 2010. No evidence of Sergio Gatron being involved, or Daniel Beltran, or Gonzalo Guevara, or Jose Rodriguez, or Ramon Galan, or Richard Ganju. Never once had their names or any nicknames. Gonzalo goes by Gonzo, for example. Hadn't come up. And so now we can talk about Thanksgiving of 2010. And let's make something very clear. These people are victims. And what happened was awful. 2 are dead. 1 cannot speak for himself. 3 will testify in person. 1 will come by video. And I want to let you know, we will have to ask them questions. When all is said and done that night on the porch, hanging out, playing cards, drinking beer, somewhere between 50 to 60 beers are consumed. Several marijuana blunts are smoked. Someone goes out and gets cocaine, and some of them take bumps or hits off of cocaine. That's the evidence. And by the way, when we talk to you about them, please, that is not to say we don't like them and neither should you. Not at all. You have to be put in their place to gauge their perception. And that's why we will talk with them. And that's why we will show them and every witness respect. But there are questions that need to be asked, and they will be answered. And here is what we have. 2 people are going to come in. I say come in, 1 by video and 1 in person. 2 people are going to come in, and they are going to say, Michael KEETLEY is the one who shot me. That's what they're going to say.
Objection, Judge? How you approach?
Holly Carp says, "Oh damn, I remember this case. This case is still going on. It's not, you don't have to remember to right now. The jury is deliberating this trial as we begin our watching of it." And Marshmallow says, "Rama Lama Nama Nui, to you, it appears that this man has not been healed, but I assure you that his soul has been healed. Insane clown posse."
That's the juggalo. The juggalo is in the house.
It is. That'd be fun if he's got juggalo tats on him. The defense lawyer. The defense lawyer is a juggalo. All right, let's burn through this here. That was fast. That's what is that? I'm not keeping track of the objections. I think that's number 6. We got to Duncan, Idaho. Before we jump back in. Well, now I feel like an easily swayed / manipulated rube, blowing this way and that after each side makes their statement, not their argument. Makes for more super chats, though. Oh yeah, definitely keep super chatting, and that's how you should feel.
That's true. Well, except that I would say no. That right now you should presume him not guilty, because unless the state provides you evidence that you believe it put him in as the shooter beyond a reasonable doubt. The presumption, the place where you should be at right now is interesting. Let's see what the evidence says, right? And it's going to be up to the state to show him proven beyond a reasonable doubt.
Yeah, that is what I was saying after she finished. I mean, if it's a good opening statement by the prosecution, you should be thinking, maybe there's something to this. Because if you listen to it and you think, yeah, nothing she said makes any damn sense, then that's not a very good prosecution opening statement.
Well, and what the defense is saying now, first of all, they're saying he's physically incapable.
Yeah.
So they're attacking that. Two, they're saying that the motive that the state is saying he's obsessed and all this, it is not portrayed. So we got to look and see how he portrays himself in the lead up to the shooting, right? And what else? He's also gonna say that the eyewitnesses, the victims, the testimony will not put him in the place. Yeah.
So by the end of this, you should be squarely back to where you should have been, which is what Steve was saying, is you just have to, you should be back to the point where you are assuming that this man has been falsely accused and falsely charged, and the prosecution has to present evidence to change your mind beyond a reasonable doubt. And I did love how he said, I know I mentioned it before, but I did love how he said, not guilty unless, not
I'm
guilty.
going to share that with our trial team. I like that a lot.
I did like that. All right, let's continue here. Thank you so much for that super chat, Duncan, Idaho.
As I mentioned, two people will come in here and identify Michael Keetley. Jose Rodriguez will testify by video replay and say Michael Keetley was the shooter. Gonzalo Guevara will come in here and say Michael Keetley is the shooter. So it seems like there's really nothing to question. I want you to anticipate testimony from Dr. Jennifer Dysart. She will be called by the defense. Like Dr. Halpern, she is very skilled. She is very credentialed in her field. And she deals with the issues of identification that people make. Dr. Dysart will testify about a couple of things. One, she will testify about something called estimator variables. And these are factors related to the witness and their opportunity to see a perpetrator at the time of a crime and to make a correct identification. When you hear from her, you may want to have your notepad ready. I can't obviously tell you what to do, but there are certain factors that she will talk about. One, she will talk about duration, the time to see the events. In other words, as she will say, the more you see, the more you can be accurate. Now, when Ms. Johnson talked to you, she blended the statements together into a narrative that is cohesive. But that's not how it works. We're going to step witness by witness very quickly. And in fact, there is conflict in their statements and testimony that you will hear. To some extent, that can be expected. Now, what everyone will agree on is that this was a quick event. It happened fast, and it happened in seconds. We'll talk about this so much. You may think, man, this is an event that took as long as jury selection, but that's just not true. It's quick, and it was quick. That's the second thing that you will hear. Not only is there duration, but there's exposure, the ability to see the event. And not only was it quick, it was dark. The evidence will be that there is no street light in front of Ocean Mist. There was only one small porch light. A shadow comes, a shadow shoots, a shadow goes. Dr. Dysart will ask you to consider weapon focus. Was the witness focusing on the gun? Again, there will be conflict in how the shooting occurred. For example, Gonzalo Guevara will say a first shot was done in the air, while Ramon Galan will say, no, that first shot hit me. But on this, almost all agree that a black pump action shotgun was used. A black pump action shotgun. Black pump action shotgun. That's what was used. Daniel Beltran and Jose Rodriguez should tell you that after each shot, the shooter had to rack and shoot. Rack and shoot using two hands. Dr. Dysart will ask you to look at stress and higher arousal.
What was that?
Is there a pump action 45?
See, that's what I'm not seeing here.
I've never heard of a pump. I've heard there are pump action 22s, but I've never heard of a pump action 45.
I never have either.
You know, and it's,
I mean,
you
clearly he's not just saying it was a regular shotgun being used. Clearly, he's not saying that.
It sounded to me like he's saying that the shots are being through a pump action, which.
But I mean, like a shotgun, not like a pump action long gun.
I don't know. Let's hear what
because a shotgun injury to the back of the head would be much different than a 45 to the head.
Well, yeah, I mean, they're like, I'm skeptical about firearms tool mark matching, but this is one thing that firearms testimony can talk about, which is this was a 45 caliber round to the head. This is a 45 caliber jacket, automatic hollow point or whatever, right? I mean, that is stuff that can be demonstrated. For him to say this is a pump action shotgun, I mean, I don't know. Let's hear what. I'm like, my ears perked up. I'm like, what's he?
Yeah,
saying?
this got really weird really quick.
Yeah.
All right.
Also, the ability to see something sudden, to encode it and process it. Not only process it, to accurately store it, so that when you tell it again in the future, you are actually telling something correctly. She will talk about own group or own race bias. It's not a pejorative. It's not racist. It's that certain people in certain groups are easily able to identify within their own group. It could be age. It could be color. You have cross-race identification in this case, in that they claim it was a white person who did it.
All white people look alike.
Alcohol and intoxication. It should
Koreans
be obvious,
tell me.
Dr. Dicer.
Well, no, there is what he's saying here. In fact, I even reached out to my buddy Brian Cutler. Dr. Cutler is the leading expert on eyewitness identification and memories, and I've reached out to him about this because cross-racial ID is a thing, and I think I talked about this. Was it on your stream or it was recently on somebody's stream? So basically, what that means is people are much better about identifying faces within their own race. Cross-racial ID is a difficult thing. And so he's saying that if this is a Hispanic or a Black witness, they will have more difficulty identifying white perpetrators. Like you said, Koreans, all those round eye, big noses look alike, right?
Yeah, and the same way we say that about them. All Asian people look alike, all Black people look alike, whatever.
Cross-racial ID is a general matter, so he's correct about that. He's also correct about the way memories work, and about it doesn't necessarily connect in. So this is great stuff. I'd like to see these experts. I'll definitely tune in for the experts, if nothing else.
It's about 18 months of being in Korea when I was so happy that I started to notice like different shades of brown eyes and the different shades of brown hair and things. You're like, oh wait, I've been here a while. I'm becoming one of us. So anyway, let's jump back into. We've got about another 15 minutes of this. I think 15, 20 minutes, and then we're done.
And the issue, lastly, is going to be on prior familiarity. Hold your ticket stub for a minute. We'll come back to that.
Well, and while you're holding your ticket stub, I forgot to do these two super chats. Well, these two chats. Matt says, don't defense risk shifting the burden of proof to themselves when saying he is physically incapable.
Well, it is evidence that they're going to present in defense, that they're previewing what the evidence will be. You always have to be careful of that shifting the burden question. Yes, that is something you always got to keep first and foremost in your mind.
And Vince Clortho, should the juries be required to see 12 Angry Men first? I don't know if they would see that, but if you are going to do it, watch the Ernest Borgnine one, not the Ted Danson one. Not Ted Danson. Was it Ted Danson that did the remake? I think it was. But anyway, yeah, no, it was Jack Lemmon, not Ernest Borgnine. I was talking about Poseidon Adventure earlier. Yeah, the Jack Lemmon version of 12 Angry Men. They should, but I think this is a topic for another day. We briefly touched on a few days ago, but I think there should be some sort of jury training between jury selection and the beginning of the trial. But yeah, I'm in that camp. Something needs to be done. But what that might be and whether anyone agrees with me is a discussion for another day. And Bad Weather Biker says Taurus makes a 45 long Colt pump action rifle. If it's Taurus, it's probably likely to blow up in your face.
No, I don't think so. Taurus is all right. No, I didn't know.
Just joking, Taurus.
Yes. No, I didn't know that. That's interesting. That may be. I don't know. How common is that? I've never seen one.
Yeah, the jury doesn't have the burden of proof, regardless of what I said earlier. It seems I said the jury has a. Anyway, yeah, we all know what I meant. All righty, let's get there. Let's now that we've got our ticket stub, let's get back to the action here.
going to be on prior familiarity. Hold your ticket stub for a minute. We'll come back to that. I want to talk to you quickly about these witnesses. Ramon Galan started the night at his cousin's house, hanging out with his cousin Rosemary. Juan Gatron was there. Richard Cantu was there. Richard Cantu was driving. Ramon probably had 4 or 5 beers there at some point in time. They leave Rosemary's.
I was
they go to the
joking.
gas
Taurus is
station,
a
they get
great
12
weapon.
pack of beer, and they come over to Ocean Mist. Ocean Mist is a dark street. The lighting is, as Mr. Galone will tell you,
Ocean
just
Mist sounds like a
porch light,
girl's
where the
cocktail.
porch light was lit up, but like the road and the yard, it's dark. After a while, they decided they were going to go back to Rosemary's. So Ramon Galan is on the step.
To see the jury. I don't need to see the screen. That's fine.
Delete the browser history. Ooh, that's technology there.
We're going to show you the step in just a second. But as you do, to be good with your time, Ramon Galan is at the bottom on the first step. He all of a sudden hears.
This is why you have
somebody.
associates.
He's going to be right
Pinch
about-
and zoom, pinch and zoom.
pointing at the bottom first step on the right as you're facing the picture. Everybody else is up on the porch. He's waiting for Juan. He's waiting for Richard so that they can go back to Rosemary. And at some point in time, up comes a person who says, "Give me your ID."
Bye, Haj. It
Give
was
me your
nice
ID.
having you here. Go troll somewhere
Turns
else.
And he is shot. That's the first shot. It was 1 to 2 seconds. He could not tell ethnicity. He will not be able to tell voice, height, weight. It's a silhouette. Doesn't know anything. He just remembers being asked for his ID, nothing about Creeper, and being shot. That's Ramon Galan. Daniel Beltran will arrive at this place, Ocean Mist, around 7 o'clock. He's with his buddy Diego Lucas. Diego Lucas is not on the porch when this happens. Diego Lucas is going to be inside this house. There are people inside this house who are asleep. None of them see anything. They may hear some stuff, but they're not eyewitnesses to what happened. He's not sure how cocaine gets introduced on the porch, but he's going to use it. He smoked marijuana. He drank beer. He's going to say that he saw a minivan. And despite what Ramon Galan says, apparently they all talk about it. Hey, there's a minivan. Drive. The car leaves and then comes back, and now it parks somewhere in front. And by the way, this does not give you a great idea of the situation because this is lit up by sheriff lights. This is dark. And this is not many feet from the road. It is very close to the road. Daniel Beltran will say that the shooter was between 6'1" and 6'2" inches. That the shooter was wearing black boots that were laced up. That the shooter was 250 to 280 pounds. A big guy. That's who the shooter is. Daniel Beltran was facing the house when this started because when he says he was told to get down on his knees, he did, and he faced away. And the shooting was loud, and the shooting was quick. He describes a pump-action shotgun, black, knows it for a fact, holding the gun with both hands. The trigger and the stock is in his right hand. The barrel is in his left. Since it was a pump action, had to shoot and pump between rounds. Everyone but Juan was facing away. He will say that the shooter...
There's always Juan.
...or others after he was shooting. And yes, he will agree this was just a matter of seconds and that Ocean Mist is, in fact, a very dark street. This takes us to Jose Rodriguez. Jose Rodriguez was on the porch. He was not shot. Listen carefully when you see his cross-examination today. He will have to be corrected on several occasions. More than once, he'll have to look at prior statements. He will be the only one to claim that the shooter arrived in a van and was playing loud rap music. The shooter, large, 6'1" to 6'2", 250 to 270 pounds. This is happening fast. he will be another one to tell you this.
Like Carmen
It is
Miranda. there.
undisputed that he
Charo.
was drinking, smoking marijuana, and snorting cocaine.
Coochie.
And
We're
now
old.
we have to tell you more about Jose.
You're like Charo? Who?
This happens around 2:20.
Oh, that's great, man.
A couple minutes after in the morning. The police come. The police talk to him first, and he will say this both to the prosecutor and on cross-examination to the defense. He, in spite of all of this, has the wherewithal to mislead the police. Listen for it. People are hurt, being airlifted, and he will say, don't know nothing about freedom. Watch for it, because it will come. And Jose Rodriguez was asked initially, and you know what his response was when they talked about the shooter? I have never seen this man before in my life. I have never seen this man before in my life. Police will get a series of photos, including Michael KEETLEY's picture, and a deputy or other officer not involved in the investigation. He will show him the photographs. Michael KEETLEY involved in that. And you know what Jose Rodriguez does? Doesn't pick out Michael KEETLEY. So the evidence will show drove through that neighborhood.
Nice three-dog night blast there.
Around in his purple ice cream truck. Jose Rodriguez has been on that porch just feet away. Michael KEETLEY's stunned. Jose Rodriguez has been on that porch.
That's
and
what it
watched
was,
his
Tony
kids
Danza.
buy ice cream, nachos, whatever. Maybe not even always having to pay.
I'm still loving the idea of an ice
Jose
cream and
Rodriguez,
nacho stand.
on 8 to 10 occasions has said, I bought from that guy. I have never seen this man before in my life. So what changes? Well, very shortly after 2 o'clock in the morning, a text is sent out. This is a text that will change everything. To borrow from James Thurber, this is where confusion will get its foot in the door. This is the guy who shot Magic and Spider. I don't know what that word is. If anyone sees him, the cops are looking for him. It's the same guy who got shot in OSC, Old Sun City Center. He was the ice cream man back in January. Where did this come from? I don't know. It was forwarded and 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 forwarded. I think I can say that many times. A man named Juan Hernandez, who heard about the shooting, within 2 hours or so, comes to Ocean Mist. And then he's later going to look on his phone. He gets the text. A cascade of unreliability and suggestiveness begins right here. Because you know what Juan Hernandez does? He goes to Jose Rodriguez. You know that guy? Yeah, it's the ice cream man. He's the shooter. And so now, under that, Michael KEETLEY did the ice cream. Name the investigation, name the case based on a text. Can I tell you something? Do you want to know where that text originated? Do you? So do I. Police never followed it up. It went through Riverview. It went through Ruskin. It went through Mama. Can you believe it? It went to Texas. A state witness by the name of Carol Orduno may testify. She got the text. It's going everywhere. Michael KEETLEY did it. And when Juan Hernandez says, I'm not going to tell you where I got it, the lead detective in this case says, okay. Curious that this text is going out, as the evidence will show, there was no eyewitness. Jose Rodriguez has not given a full statement. Gonzalo Guevara is in the hospital. He will not talk for days. Daniel Beltran, he's in serious condition as well. There are no home cameras or surveillance footage. No one on the porch spoke to law enforcement besides Jose Rodriguez, who said, I have never seen that man before in my life. One picture changes his tune. So that is why we're going to argue that this is a case of misidentification. And that is why we will cross-examine these people. So let's talk about Gonzalo Guevara. He cuts hair all day. He was on his feet. He doesn't really want to go out, but friend kept saying, and finally goes, okay. He goes out with Sergio. He goes out with Walter Lucas, again, someone who lives in the house, but is not a witness to what happened. He has seen the purple truck frequently. He knows Jose has bought from the purple truck frequently. He would see this in person. He says he didn't really pay attention. And he was on the porch, which I think he estimates anywhere between 40 to 50 feet away. A little bit more than a first down in football. He has a dark minivan showing up, a man getting out, looking nervous. He describes this person as a chunkier dude like him, but a little taller, like way taller than me. Gonzalo Guevara is 5'9", 225. This man is 4 to 5 inches taller than him. This man is 280, maybe 290, maybe 300 pounds. To use the words that Gonzalo Guevara has used before, he's got a chunky, fat body.
I resemble that remark.
Significantly, Gonzalo Guevara is going to say, this man walked up. Oh, by the way, Jose Rodriguez, my bad, I forgot. Do you know what the shooter did? According to Jose Rodriguez, he speed walked. Walked up real quick, walked up real slow. Nobody's going to talk to you at all about any physical disability. Nothing unusual about the hand. No uncoordination. This is a fat, overweight, chunky guy who did this, and he did it quickly. He did it in the dark. That is going to be their evidence. That is going to be their testimony. Gonzalo Guevara has the shooter with a gun in a left hand and a badge-like thing in his right. Significantly, Gonzalo Guevara is going to say the shooter fired a warning shot in the air. And he did it with his right hand. So somehow that gun will get from the left hand, the badge will be put away, and the gun will get in the right hand and it will shoot. That is going to be Gonzalo Guevara's testimony. And let me tell you, when Gonzalo Guevara goes to the hospital, I'm not to say good for him, not good for him, but good for him that he has supportive family. People come, sisters, brothers. The neighborhood is talking. Everything happens so quick. That's what Gonzalo Guevara will say when he has a chance to speak. No physical disability, just overweight, just not in shape. Had brown, orange hair, prescription clone glasses, had the black pump action shotgun. He's going to describe some type of vest being worn. As you hear the evidence in this case, I'm going to ask you to wait again for Dr. Halpern. The evidence will show Michael KEETLEY does not have the speed, agility, dexterity, or coordination to do what their victims say was done. Let's also talk about Gonzalo Guevara. This is something significant. In jury selection, we talked about rules, we talked about procedures. You're not going to be surprised to hear that Hillsborough County Sheriff, they have rules, they have procedures. They have standard operating procedures. This is going to be significant. How do you do an eyewitness procedure? I want you to keep in mind. Now, what happened with Jose Rodriguez originally was blind administration. An independent administrator administered a test, not knowing the desired answer. This person would not be aware which person in the photos or lineup is a suspect, and would eliminate the possibility of unintentionally influencing the witness's selection. The guidelines set forth in this standard operating procedure will be used. The guidelines will be used, or shall be used, under various circumstances when dealing with eyewitnesses. Eyewitnesses play a vital role in solving crimes, where in some cases, the only evidence that may exist is the testimony of an eyewitness. It is also important to keep in mind that eyewitness testimony may exonerate innocent parties. Procedures surrounding the police lineup have remained unchanged, but research and DNA exonerations have proven that eyewitness ID can be somewhat flawed and should be handled more effectively. It is the intent of the Hillsborough County Sheriff's Office to seek more reliable procedures for eyewitness identification and ultimately mitigate potential misidentification. That is the rule. Why did I tell you that? Because the lead detective in this case, Jose Luba, did not follow these rules. He specifically and willfully chose to break policy. And what he's going to say when that text message is already out there, he's going to come by the hospital and he wants to show photographs to Gonzalo Guevara. And the medical people are going to say, not today, he's hallucinating. And he comes in and he says, I'm going to come back tomorrow. And he Gonzalo's like, show me today. His family's in there. He's like, no, I'm going to show you tomorrow. You remember my name, Jose Lugo. That's what he's going to say. And you know what happens? The next day, they demonstrate a photo array. The next day, they demonstrate a photo array. And now, Gonzalo Guevara is going to say that he is 2,000% positive. There's going to be quite a bit of discussion about this right here, this 3/4. So I want you to preview for that Gonzalo Guevara originally picked 4, then it was changed to 3, and the 4 there. There's a lot of question marks about how this was done. We know it was in violation of the rules, and we know it was done sloppily. What we will also hear from the evidence is it was not recorded, so you cannot see it, you cannot hear it. He identifies Michael Keetley by 2,000%, even though Michael Keetley has never been anywhere near 300 pounds. Even though he's never been anywhere close to 300 pounds.
I'm surprised they're letting that ID in.
Yeah.
2 eyewitnesses in this case.
I can see what that problem.
Identification of a man who's been coming through that neighborhood for years. So by now you're not surprised to hear we're going to challenge every bit of the state's evidence. And we will brush away things that will not need to be challenged. Don't be scared. I could stay up here for a lot longer. There's going to be cross-examination. Wesley Smith, he shot on that property. Wesley Smith, there's a lot to say about him because what they say he said, he waited a long time to say. He cannot tell you specifically what, he cannot tell you specifically when, and it was only after he started watching the news and the news and the news and the news. And David Beckwith, they didn't tell you he's a convicted felon who put a gun to Michael Keetley's head, a .45 to Michael Keetley's head, took off with the gun.
Oh?
They told you about painting a van, changing the van. The bumper was two-toned for resale value. They talked to you about a change of a barrel or modification. They will not have one witness come in to say that Michael Keetley ever did that. I'm going to ask you to keep in mind when you hear the government's questions. For Ms. Johnson got up here and talked about computer search. She says that Michael Keetley made all these searches. The truth is, they cannot show that Michael Keetley ever made one. The truth is, they were selective in what they wanted Michael to be searched. And they cannot even tell you what it means or put it in context. So yes, Michael Keetley or others used that family computer. And yes, Michael Keetley was interested in finding out who shot him. I have to address something last because they talked about a statement that Michael Keetley made. That he denied Creeper. True. He knows Creeper. True. He might be told the truth. True. Michael Keetley is Weston. Michael Keetley is Old Sun City 7. Michael Keetley is Waimama. And there's a text going around that says he did something he did not do. How do you defend yourself? because they didn't put it in perspective. They stopped
Judge,
him.
I'm gonna object to this argument.
I'll sustain. Mr. Grant, leave it to the facts and not conclusions related to this fact.
Here's the evidence. They said that he gave a statement. What they didn't tell you is they pulled him over that night. The police did. On the road for an hour, Detective David Schramm comes up to him, not recorded, and says, hey, let's go back to the sheriff's station. Let's do an interview. We want to talk to you about the case where you were a victim. That's what we want to talk about. He goes there without a phone, without transport. He's taken to the station. They put him in a room. They talk to him about the case. And they say things like, hey, judge me for me. We're not going to BS you. They talk with him a little bit. The first statement ends at the station, and he goes and sits outside for 45 minutes. No car, no phone. David Schramm sees him, says, I'm going back to your house. I'll give you a ride. On the way back, another discussion is had. And in that other discussion, there are things said by David Schramm. And what are they telling him? They start saying, we think you did this. We know you're the one who committed this crime. They say to him, we've been planning to get a search warrant since 10 o'clock this morning. David Schramm will have to admit that's not true. They say Detective Schramm and his partner, they say, we've got someone who puts you at the scene. That's not true. They say, we're going to take over your case. We're going to find out who did what happened to you. That's not true. They say, we have phone records which put you at the scene of the crime. That is not only not true. Michael KEETLEY says, terrific. If you've got my cell phone record, you can know where I am. Do it.
Do it.
They never do. They never do. They have the ability, and they do not do it. That is what the evidence will be. Detective Schramm says, we've got somebody who can describe you to a T. However, he does not fit the height, he does not fit the weight, he does not fit the hair color. They even say they've got his actual work glasses that they've recovered. Time and again, the police use what they may call tools or strategic questioning, but what are really intentional misrepresentation and deceptions to get him to say, you did it. And consistently, he says, no, I did not. So there's a lot to come. And the time to question witnesses begins now. I'm going to ask you to I'm going to ask you to presume Michael KEETLEY not guilty, presume him innocent because he's not guilty. I'm going to ask you to listen to the evidence and hear the testimony. And because of what is lacking and because of what is conflicting and because of what there is only one conclusion that you must draw. And that is that Michael KEETLEY is not guilty of all counts.
Wow. Excellent. Excellent. He's real intense. He's at a high emotional level all the time. And it's interesting, but I mean, I will say that was much better. That was an excellent opening statement.
So you think the defense did much better than the prosecution?
Well, I think so. I mean, it sounds to me like they've got a lot to work with here. Very good. Impressive. I like this defense attorney quite a bit. He is who he is, right? The people are saying, well, he's yelling and he's emotional and all that. But first of all, he believes in his case. I get that.
Yeah.
And I get the fact that he is emotionally invested and he didn't let these objections sideline him and he did exactly what I train my trial attorneys to do.
What's that?
And that is when there's an objection to your opening statement, you immediately go back to the evidence will show and then say what you were going to say anyway, right? And which he did. And it was he didn't let it rob him or rack him at all. And so I can see where there's reasonable doubt in this case. I mean, and again, this is why this firearm shell casing matching is so problematic, because it's physical science evidence, supposedly, that is very inculpatory. When you have problems with eyewitnesses, you've got descriptions that don't match. You've got injuries to hands that make him physically incapable. You've got so it sounds to me like there's a lot of problems here. But what do you think?
Oh, I like that. I mean, the delivery, he's a great rhetorician, a little hyperbolic at some points, but I thought it was a great delivery. It was captivating. It kept you locked in, even at the 1.25 speed. I like the way it was presented, and said I just like you said, the way he got things in that were kind of borderline, and I don't think the prosecution was anywhere nearly as engaging as that. It'll be interesting to see what the evidence shows, because there's a lot of that. There's a lot of evidence that's going to have to be shown to prove what the prosecution says they can prove.
Well, it looks to me like the prosecution is basing pretty much their entire case on the eyewitness testimony of two victims who are multiple convicted felon kind of gang kind of people who have threatened. So they're putting all this weight on these victims, right, which are supposedly victims. But if it's a gangland type shooting, which sounds to me like usually that's what this type of thing is. Yeah. Those gangsters are not going to want to point the finger at the rival gang. That's not what you do, right? You're gonna, and the prosecutors want to give you a break and give you a deal by dressing up your testimony. Then they're going to do that. They're going to, oh yeah, well, who do you want me to finger? The ice cream man? Yeah, that was him all day, because he's not involved in the gang warfare. So yeah, I can see why this has been a hung jury. I'm a little suspicious. I'm a little curious why. Well, at what point does a prosecutor give it up? Because somebody had said that the previous trial was 10-2 not guilty.
Yeah.
So, that's the kind of thing where, it may be that he just said that they offered something like, how about probation on a felony battery or something? And the guy's like, to hell with that. I'm not guilty, period. I'm not taking any deal. That may be. But I don't know. I mean, at what point does the prosecutor say we're not retrying because if you poll the jury and it's 10-2 against the state, that's a lot of reasonable doubt.
Yeah.
So why are you going forward again? The state has to go forward on cases that you can prove beyond a reasonable doubt. There are some cases that are almost solved, sort of solved, not quite there. And if it's 10-2, you've got a jury of people who have reviewed the evidence and say 10-2 not guilty. That to me is, there's a lot of reasonable doubt. Don't go forward prosecution. So why are they retrying it?
I can't disagree with anything you just said. That's a huge indication that your case isn't as strong as you thought it was.
A lot of it egos get involved. Yeah. People get solidified. I don't like this defense attorney. I hate that justification. As a prosecutor, I remember, because there were defense attorneys I loved and ones that I didn't like, right? But I would always subtract that out of whatever equation that I did, because the defense attorney, your personal opinion about them makes no difference in the case. Noses get out of joint, egos get involved, but the personal thing, the defense attorney is not the person that was accused. And, and their job is to zealously advocate, and personal interactions get mixed up in it. I don't know. I'm not sure if that's what happened here, but I'm just curious why the state is bringing it again when there was a 10-2 not guilty verdict or mistrial before.
Well, let's see what they show. Flux says, I never feel guilty smoking weed until we watch trials and the defendant has used the marijuana and makes it sound as bad as a crazy meth head, reefer madness.
But the thing is that you can do DUI on marijuana, and marijuana has gotten a lot stronger in recent years, and it can often be laced with chemicals that are very, the thing is, Flux, listen to your brother. I'm dealing with a case right now that's a DUI homicide, double DUI homicide, and it's intoxication by marijuana. So, it all sounds well and good, and people want to defend their weed, but you're driving your truck and you run over, kill two people, or it's easy to make light of, and people want to have their drug of choice, whatever it may be, but it affects different people differently. Most people, it has no effect. Most people, it makes them lazy and edible and hungry. And munchy, but there are a subset of people that it has a profound effect on, and you don't know what it's laced with too. And of course, motivation is something we all have problems with. So even if its effect is only motivation, I would suggest that motivation is something we need more of, not less.
And you and who's Arme says, Jeff, were you aware that your dog sounds exactly like a Tusken Raider from Star Wars? We were rolling over here listening to the audio clip. Okay. It's weird that you can hear. Well, we can hear the dog barking, which was, I don't know what the hell was Yoda's problem. Yoda's got issues, but people were saying you could hear him. Yeah, it's like Fedorovsky's. Why is there a sound of sleep apnea in the background? Like I couldn't hear. The dog was literally snoring under my desk, and I couldn't hear it. I don't know how everyone else was hearing it. That was weird.
People say that there's nobody lacing weed. Let me just say that we do Baker Acts. We do Baker Acts, which is people that are involuntarily committed for mental disorders. And I have seen multiple people who are catatonic from smoking laced weed. So you just don't have the perspective and experience and what we deal with in the public defender's office. I understand people want to minimize and defend, but
in the crime world, everybody does everything possible to drugs.
It's do not minimize. I recognize that, I'm an outlier and I'm going to scold or whatever and too straight. But, when you see what I see, it may be outliers, but it does happen. And don't discount the fact that it doesn't. It does, right? So,
yeah.
Cheers to you.
Anywho, this isn't a discussion chat.
I'm not pouring rain. I'm just saying, when you see cases that, the things that I see, you get a little warped. And, and it's the fact that you say, oh, no, it never happens. And that's not the way it affects me. And then all of a sudden you're in my office facing double DUI homicide. And, there it is. So.
Yeah, there you go. We got one more super chat, then we'll get to the non-super chats. 3 non-super chats. But first, the last super chat that we have on the roster from Chaos Coordinator. Have ice cream truck near my home. Shall I hide? I don't know. Let's wait till this is over, and then we'll decide. We should probably always hide from ice cream man. That's just kind of a general law of nature.
Little David Lee Roth going there.
Yeah. And all right, we have a couple of things here. One of our spam people, if Legal Vice has lost a little weight, he'd be nice. I'm already nice and I'm super hot. But yeah, that's the whole point of going to the gym and stuff. Ooh, you're so clever with your spamming troll bots. Ooh, God, I guess I better quit my YouTube channel now. Legal. Okay, well, this is the big one. Then we'll get to a short one. Legal Vice, is burden shifting actually a legal thing? Like if the defense burden shifts to themselves, are they required legally to provide proof of something, or is it more of just a jury thought?
Well,
Steve can answer that question.
Yeah,
he's written articles and chapters on this.
In fact, there's a chapter in the book on ideas and answers in law about prosecutorial burden shifting, which is that the defense has something to prove. Now, there are things called affirmative defenses. For example, the affirmative defense of duress is a good example, or the affirmative defense of insanity, in which the defense does have a burden. So it is an excuse for the reason that I took the car is because the guy put a gun to my head and said if I didn't take the car, he'd shoot me. All right, so duress could be a defense to grand theft auto, all right, in that particular case. But because the defense is in a position to the state is not in a position to prove that or disprove that. That's you don't call it an affirmative defense. Same thing with insanity. It's within the control of the defendant in which to put up that defense. So there are places which the burden does lie with the defense. And there's also an article, I will say, in the Ideas and Answers Law, if you want to really get into this issue. In fact, it's the first chapter in here, which is the burden of proof in a prescription drug affirmative defense case. That's chapter 1 of Ideas and Answers in Law. And that goes all through about how this is screwed up in Florida and how we have 2 burdens of proof for if you have a prescription. And that is, so people have prescription pills and they say, well, if the defense has the burden of proof, then the state doesn't have to prove anything. All they have to say is you're in possession of prescription drugs. And the jury can disbelieve your prescription and you can go to prison for having a prescription drug because this jury disbelieved it. But if the burden's on the state, which is what I'm suggesting should be the case in a prescription drug case, then the state has to put up some affirmative evidence that you do not have a prescription. So that's in Ideas and Answers of Law, which is still available at stevegosney.com.
And that kind of wraps us up for the evening. We finished a little bit later than I thought we would, but what's going to happen is tomorrow we will do the afternoon session where the witnesses begin. We'll burn through the afternoon session tomorrow, and then we'll go day 2 morning on Wednesday, and that's my Wednesday, your Tuesday. I think. No, it'll be your Wednesday too. I hate these time changes and screw time zones and international date lines and stuff. It makes it so hard to talk about because I say my morning, it's your night, but my night is also my morning. Anyway, tomorrow, just whatever that means, the next day, and the next day we'll be doing the morning session of day 2, et cetera, until we get to the end of this, if we hold our interest. And looks like we're enjoying it so far. We've got 904 concurrent viewers and 934 likes. So looks like we're liking it so far. So we'll see how the witnesses' testimony starts off tomorrow. Just a few things before we go out of here. Thank you, everybody, for hitting that like button, and make sure you subscribe as well. How did we do on subscribers? We picked up a few subscribers. Great. More is better. So any of the 851 of you that haven't subscribed, everybody's signing off now because we're reaching the end. But on your way out, please hit that subscribe button. Let's get me to 50,000 subscribers. We're 14,000 away. Let's do it, and then we'll have a great, big, huge party for it. And then when you're done hitting subscribe and done hitting that like button, you're always welcome to take the polls. And today's poll is ending right now with 22% of the people saying they hit like and subscribe because they have something to do now, meaning watch this trial. 31% said they hit the like and subscribe button to vote for Let's Do This trial. And 47% said they crushed the like and subscribe button to vote for Let's Get Steve Gosney on here. And he answered your summons, but he will be unavailable tomorrow.
Hey,
He's a
thank
busy,
you very
busy
much,
man.
Jeff. Thanks for letting me on, and always fun. This is an interesting trial. Like I always have something to say on these Florida trials, right?
Yeah.
So
and while after you're done liking and subscribing my channel and doing everything. Oh, we did get one clarification about the Jensen trial from Salvador Dali Parody on my Twitter feed. The Jensen trial, the funniest trial I've ever seen. The guy had 800 dick pics that he had organized by size on his computer. The appeal set a state of Wisconsin record for the number of times penis was mentioned in an appeal, 114 times. Okay. All right, that could be interesting for like a Halloween stream or something, something a little bit off the rails. And our final question of the day, once you go to stevegosney.com, right down there, stevegosney.com, once you go there, is there any way of ordering your book in hardcover?
Yes, well, that's a good question. The hardcovers are really reserved for special times and moments. I'll probably do another auction for a prepare hardcover, and also when I do if I do any kind of meet and greets where I can bring hardcover books, I will do a ticketed meet and greet in which I will sign a hardcover of your choice, which I think is going to be upcoming in June 30th in Charlotte, North Carolina. So that's a Friday night. I'll do a meet and greet, and I'm planning on thinking about doing a ticketed thing, and you can have your choice of the first edition, second edition of Ideas and Answers of Law hardcover or prepare hardcover. And I will be there and I will sign it for you. I haven't figured on the price or details yet, but that's the kind of thing that the hardcovers are really reserved for people like Legal Vices and Rackets who sell lots of books, and for people like Let's Go Brandon or Stephen Cooper, people that donate, a big chunk of change and things like that. It's mainly because I really want you to read the content of the book and not just buy it because it's a collectible. I mean, if you want to do that, then pay for it, right? But it's really more of I want you to read the content, and so it's a really well printed book. I must say, I've upped the quality of the paper. I'm real proud. I've spent some money on the design. I try to give you a really good product in the soft cover, but it's like double the price for a hardcover, and it doesn't make any more money for me, and it's the same content. So that's why I'm saving the hardcovers just for special occasions.
All right. So that answers that burning question. But you know what? The hardcover and the softcover all have the same words. Go to
Exactly.
stevegosney.com, order both of his books.
And if you really, really want it, keep an eye out. And you can, if you really, really want it, you got to compete against your fellow bidders, or there will be special conditions attached, and then it will mean something, right? It'll be more meaningful.
And thank you to everybody that stuck around here today. Thank you for joining us. Come back tomorrow for the afternoon session where we start the witnesses. Thank you, mods, for doing all that you guys do. So great to have you here. Thanks for the help. And thank you to all the people in chat. Legal Vices chat rocks. One of the best, if not the best. Clearly, it is the best, actually. Chat on the entire YouTube platform. Thank you so much for the generosity with the super chats. That is always, always deeply appreciated. And thank you for the subs. We'll see you all tomorrow. We'll see Steve Gosney when he has the time and opportunity. Thanks, everybody. See you tomorrow. Larax out.